It was directed by the Chief Justice.
Please show me the direction.
Second last paragraph, my lords.
Affidavits have been exchanged.
No, my lords, it was directed to be submitted before 7. They haven't submitted, my lords. Kindly take this up for hearing, my lords. Urgency is that my goods have been detained, my lords. It's still in their custody. My lords, more 2 matters are there, my lords. My lords, some precedents.
What are the other matters?
My lords, hearing matters, both. Specific direction, no affidavit files. My lord, kindly take it up.
Let
maybe-
me see. Let it appear. There are several hearing matters pending, I find in the list.
Let the matter be at least admitted kindly.
Hearing matters are more than motions. And let us see. All these are hearing matters. Affidavits are exchanged. Please give only if affidavits are exchanged. Are affidavits exchanged in the hearing matters?
My matter, there's a direction, preliminary, but affidavit not exchanged. To launch a direction, we kindly be given, but here it will not be taken up by no, but direction is required.
At least let the matters be.
Hearing matters. Hearing include for them.
New.
Hearing will include. List. Please give the hearing matters first, then I'll take up the motions. Yes, no further inclusion of hearing matters this week.
Lordship, may I be permitted to mention? Yesterday, I have mentioned one case for inclusion, but the case not listed today. There is a specific direction of Justice Honorable Abhijit Ganguly after 2nd March 2023.
I'll just find.
Last
I'll just check.
Lord, my lord.
That's enough.
Last line. Lordship.
In this matter, there is a direction of the Honorable Chief Justice that the matter will be heard at the principal bench by Justice Gangopadhyay. So I cannot take up this matter.
Thereafter, Justice Gangopadhyay has directed and
After a direction of the Honorable Chief Justice, can any other puisne judge direct
that's true.
anything? So I'm sorry, I cannot take up this
Then
matter.
record is lying here.
I'll send it back. I'll send it back. Record for I'll
My
send it.
lord,
I'm
my
sorry, I cannot take this.
Matter.
my lord, might have your lordship indulgence. My lord,
Yes, sir, you're waiting for a very long time. Just give me a minute. Yes. Yes.
Motion. Long back it has been filed. Motion, not final.
New motion.
Motion.
Give the numbers. Give the numbers. Let me see. Let me see, because
tax matters, my lord, and I have to leave.
I understand, but chapter motion. Requisition. I'm sending a requisition. If the file comes, it'll appear, right? Yes.
my lord, might have your lordship indulgence to mention item number 74. Well, only for this matter I have come. If your lordship kindly take up this matter, if not today, then
74 is
tomorrow at top
74 is a hearing matter.
hearing matter. My lord, if not possible today, then kindly
It is
it
appearing in the
tomorrow.
list. It is appearing in the list.
My lord.
So let me see if I can take up, if I can catch up.
But if not with tomorrow, your lordship kindly.
I cannot pick and choose. I have to call one by one. Let me see.
That's
If not day after, spend the weekend in Darjeeling and then come back.
Motion matters, inclusion in the list.
Yes. Motion.
deeply
Yes,
obliged,
give the
my lord.
number.
Lordship, may I be permitted to mention? E-mentioning item number 1, Lordship.
Extension of interim order. Give me a minute, please. I'll call. Yes, e-mentioning.
Lordship,
Yes,
e-mentioning
e-mentioning.
item number 1, Lordship. May
Yes,
I be
it's a
per-
motion.
Motion,
at the motion
Lordship.
stage?
Motion stage, Lordship.
Item number 1, e-mentioning. Mr. Shah,
It's in,
yes.
খুব ভালো জজ দারুণ জজ
Register. Names have been omitted. Correction. To be mentioned, correction.
পছন্দ করি
Any other e-mentioning? Any
No,
other
Lordship,
e-mentioning?
I don't have any other e-mentioning.
Well, all the days list, please.
I am appealing for the petitioner.
Yes, what is the application about?
This is a restoration application. Lordship.
Who, have you put the other side on notice?
Yes, respondent number. Service has been completed.
So let it be restored. Within time?
No, Lordship, there is some delay. There is some delay. Actually, I was not aware about that.
So have you filed an application for condonation? No,
Lordship, explanation has been given in this.
no, you have to file an application for condonation. You cannot come club both together in this single application. Shall I make it not today? Can you come back tomorrow?
Actually, order was passed in the month of 2nd May 2023.
Yes.
The application was filed probably in the June.
When was it filed?
June, Lordship, June 6th.
So why do you say it's beyond time? Oh, a few days,
Few.
30 days, few days, yes. File a condonation application. I'll just make it not today. Come back with the application tomorrow. Yes.
Lordship, I will file the condonation application tomorrow.
Will you be ready tomorrow? I'll keep it tomorrow then.
It will be ready.
Yes? Please give an advance copy to the respondents.
Lordship.
Not today.
Yes.
Yes, you have to give the number of the can. Today itself. So it will appear tomorrow in that case. Yes, next.
Lord, I beg to appear on behalf of the petitioner, Lord.
Yes, what is the application
Lord,
for?
application for substitution, Lord. I have served, Lord. I'm filing my affidavit of service.
Within time?
Lord, yes, my lord. Within time, my lord. During the pendency of the writ application, my lord, sole respondent died. Paragraph 4 is the legal heirs, my lord. Paragraph can 1, paragraph.
Sole respondent.
Sole petitioner died, my lord.
Raman Mahato.
Yes, my lord.
Raman
Sole
Mohan-
petitioner died on 12 June 23, my lord. Legal heirs are there, my lord.
When did you file your application? July, right? Who is you're appearing? Let this be allowed. Let this be allowed. Can 1 of 2023. Affidavit of service. The applicants have prayed for substitution in place of the sole petitioner who expired on June 2023.
Yes, my lord.
12 June 2023. Paragraph, the application is filed within the statutory period of time, statutory, no? Paragraph 4. Paragraph. The application being can 1 of 2023 is allowed. Paragraph, the cause title of the writ petition be amended accordingly. Can such as, disposed of bonus.
My lord, department
Urgent certified website.
department be directed to make the necessary amendment, my lord.
Stated amended accordingly to be done. Right?
My lord, and my lord, this is a very short matter. If your lordships can take up the.
Yes, are you ready with the hearing? Can I take up the
I
matter?
do not have the instructions, my lord. If it is on merit, I can do the.
What is it? What is the
My lord,
matter about?
My lord, the petitioner kindly takes up the writ petition, my lord. The
Yes,
petitioner is the recorded owner of the land, my lord.
yes.
My lord, he is residing there with along with his family, my lord. My lord,
Yes.
just beside the house of the petitioner, there is a doba, my lord, which belongs to, my lord, the private respondents are
Where
illegally.
is your service upon the private respondents?
Yes, my lord, I have served, my lord. Further affidavit of service also I have filed today.
Earlier you've served the
Yes, my
private
lord.
respondents?
All have been served.
I'll just check, give you a
Yes,
minute.
my lord.
I think the matter should appear in the list because
My
today
lord,
it was for the application.
kindly takes up the matter
Private
tomorrow.
respondents are not there.
Yes,
Let it appear in the list. I'll consider.
tomorrow or any day convenience of your
Let
lordship,
us-
my lord, as
let
motion,
us-
my lord.
Come back on next Monday as a motion.
Motion, my lord.
Yes, if the private respondents still do not appear, I'll consider that.
My lord,
Right?
affidavit of service
Because
kept
since
on.
today is not fixed for the repetition hearing, I
Yes,
should
Milord.
not take that.
My lord, I can understand. My lord, affidavit of service kept on the
Yes,
record
it's
today,
taken, it's
filed
taken,
today.
it's taken.
Further
Then
affidavit of service filed today.
WPA তে order করুন, let the matter appear under the heading motion on Monday. Monday is 7th, on
Monday.
7th August.
I am deeply obliged, my lord.
Next. Yes,
My lordship, I'm the petitioner, I'm the attorney of the petitioner. The petitioner is my father who gives me a power of attorney. Lordship, this is the power.
copy is on record. The copy of the power of attorney has been filed.
No, my lordship, this is the.
Please file a copy.
My lordship, this is the original attorney. Please can-
Yes, original has to be remain with you, isn't it? So you can file a copy of the power of attorney, a photocopy. অরিজিনালটা নিজের কাছে রাখতে হবে তো আপনার, তাই তো?
Okay, my
ওটা
lordship.
একটা জেরক্স করে ফটোকপিটা ফাইল করুন। What is the matter about?
My lordship, this is a contempt petition.
For appearing for the first time?
Yes.
Have you served the other side? No.
My lordship, I served the other side, but I have make a mistake in the petition that I party the as a respondent, the private respondents, as the orders passed in favor of the state respondent. So I want to expunge respondent number 5 to 11.
You want to expunge, very well. You have come up in the contempt application against which order?
My lordship,
7 June?
yes, my lordship. No, my lordship, 14 June 2022, in connection of WPA number 174 of 2022.
You have come up against 14 June order.
Yes, my lordship.
So in the 14 June order, there is no direction.
My lordship, in next phase, there is a direction that,
Ensure strict compliance.
yes, my lordship.
So you say that this has not been complied
No,
with.
my lordship, not at all. And after passing of this order, they made at that possession decreed land of the petitioner. They made an illegal unauthorized construction of 2 storage building. They blocked the way of the my lordship, can I say in Bengal?
Yes, you can.
My lordship, ওই জায়গাটা ঢোকার যে মানে যে রাস্তাটা আছে সেটাকে ওরা মাংসের দোকান আরো বিভিন্ন রকমের কি সমস্ত দোকান দিয়ে ওরা ব্লক করছে, ওখানে অ্যাটাচড করে কনস্ট্রাকশন ছোট ছোট উঠাচ্ছে। আমি প্রত্যেকবারই পুলিশকে এই কথা বলে যাচ্ছি, কিন্তু পুলিশ তো কোনো মানে স্টেট রেসপন্ডেন্ট এখানে কোনো স্টেপই নিচ্ছে না ওদের এগেনস্টে। আর বাবার উপরে একটা খুব খারাপ ভাবে ওরা মেরেছে, যেটা আমার বাবা মরার মুখ থেকে বেঁচে এসেছে, সেই ফটোগ্রাফস গুলো আমি এখানে দিয়েছি মাই লর্ডশিপ। And my lordship,
আপনি কন্টেম্পট অ্যাপ্লিকেশনের রেসপন্ডেন্ট হিসেবে যাদের নাম দিয়েছেন তারা কি আপনার রেসপন্ডেন্ট পিটিশনেও? Please wait for a minute, I'll just find.
my lordship, I filed an execution application on that month of my lordship,
In the title suit, the
Yes,
execution
madam.
application,
Yes, madam.
right, right,
that
yes.
is now pending. But there also I have to struggle so much because Secretary Junior Division called for that title suit, but that cannot be reached by the Learned Civil Code. That's why I filed a petition for sending that record from Jalpaiguri District Court.
You filed a separate writ petition, তাই তো?
My lordship, actually আমি একটা এক্সিকিউশন অ্যাপ্লিকেশন করেছি যেই মাসে এই পিটিশনটা শেষ হয়েছিল জুন 14 জুন সেই মাসে 28 তারিখে 28
এক্সিকিউশন অ্যাপ্লিকেশনটা করেছেন।
সেটা এখনো চলছে আর সেখানে
আপনি এখানে প্রাইভেট রেসপন্ডেন্টের নামগুলো এক্সপাঞ্জ করতে চাইছেন।
Yes.
দে আর নট দ্য কন্টেমনার্স, রাইট? অ্যাবসলিউটলি রাইট। কন্টেম্পট অ্যাপ্লিকেশনের নিয়ম হচ্ছে কোর্ট একটা অর্ডার করলে তারপরে কন্টেম্পট অ্যাপ্লিকেশনের কপি অ্যালেজড কন্টেমনারদের সার্ভ করতে হয়। আমি আজকে অর্ডার, ইট ক্যানট বি সার্ভ বিফোর অ্যান অর্ডার অফ দ্য কোর্ট ইজ মেড। দিস ইজ আ কন্টেম্পট অ্যাপ্লিকেশন, রাইট? I'll pass an order today. Please, I'll expunge the names of the private respondents as you say. আমি আজকে একটা অর্ডার করছি, আপনি যারা শুধু যারা অ্যালেজড কন্টেমনার তাদের উপরে কন্টেম্পট অ্যাপ্লিকেশন এবং তার অ্যানেক্সার গুলো সার্ভ করুন, করে পরের দিন এফিডেভিট অফ সার্ভিস ফাইল করুন, রাইট? On prayer of CPA and order. On prayer of the petitioner, the names of respondent numbers 5 to 11 be expunged from the cause title of the contempt application. Paragraph, the cause title be amended accordingly. Paragraph, the petitioner is directed to serve copy of the contempt application along with annexure thereto upon the alleged contemners and file affidavit of service on the adjourned date. Paragraph, let the matter appear before the next available circuit bench.
My lordship,
Because you have to
this,
serve
my lordship, the next
week.
No, my lordship, actually আমি ম্যাটারটা ফাইল করেছি জানুয়ারি মাসে, কিন্তু আমি আমার জন্য কলকাতা যাওয়া সম্ভব হয়নি, সেটা হচ্ছে আমার ফ্যামিলিতে মাত্র 4টে member
নেক্সট সার্কিট বেঞ্চে প্লেস করাচ্ছি পরের সোমবার।
My lordship, this application have to take by this court.
Not necessarily, because this is circuit bench.
Okay, my lordship.
নেক্সট থার্সডে রাখবো, আপনি চেষ্টা করবেন তার মধ্যে সার্ভ করার।
Yes, my lordship.
হ্যাঁ, নেক্সট থার্সডে 10th August.
Okay. Great.
Please serve and file affidavit of service on the next date. 10th August. In person. Same head, same head. Yes, next.
My lord, it is
Yes.
my application, my lord.
It's appearing for the first time.
My lord.
Please serve and come back.
My lord.
Mr. Shah, you're appearing.
Mr. Ghosh is appearing, he is on leg in court.
He has to actually serve and come back after an
Yes,
order of
my lord.
court.
Then in
Please
that
do,
event,
you
let the
cannot
matter-
serve before an order is passed in a contempt application.
No, it is not contempt, my lord.
New motion.
New motion, my lord.
Oh, I'm sorry.
My lord, pass over, my lord.
in that event,
Yes.
the matter may be taken up 12 o'clock or.
It's difficult, it's difficult. I'll make it not today. Will he come tomorrow?
Yes,
Let it.
But
let
it's
me-
very small matter, my lord. Personal hearing, want asked for was not given. Only this. Only this. If it is consent, my lord, I can go along for 45 minutes, but basically I'll have to come down to the moot prayer, my lord, whereof the personal hearing which was asked for was not given.
Violation of natural justice.
My lord, my lord. My lord,
without
Mr.
Mr.
Shah?
Ghosh is embarrassing.
my lord, let it be passed over, my lord, at 12 o'clock.
2 p.m.
2 p.m. My lord,
Very-
grateful, my lord.
It's difficult to pass over all the matters.
Fine.
Petitioner-
I will- What is it?
Huh.
5 and 6, both the matters.
5 and 6.
6 is my matter, my lord. 2 o'clock,
6 also, Mr. Ghosh.
my lord,
Yes, yes.
So 5 and 6, 2 p.m.
my lord.
I am appearing for the petition. Your Lordship. This is my affidavit of service. It is a very small matter, Lordship, the
Who is
petitioner.
appearing? Small matter, big matter later on. Who is appearing in the matter? IOC, Indian Oil Corporation.
Lordship,
Who
I have-
appears?
I have served.
But who appears generally for IOC? Indian Oil, Mr. Ghosh. Where is Mr. Ghosh? So I cannot fix all the matters at 2 p.m. Not possible. Not today? Right? Not today. Next,
Deputy Village Service.
not today.
My lord, I'm for the petitioner, my lord. My lord, the petitioner initially.
Respondents, you're okay?
Yes. My lord, affidavit of service or letter.
Only state respondents?
Yes, ma'am.
Right, yes.
The petitioner, my lord, he engaged as platform typist in the year 1990 at my lord Dinhata 2 Panchayat Samiti. Thereafter, in the same year, my lord, he was brought to the regular establishment. My lord, in the year 2014, he transferred from Dinhata 2 Panchayat Samiti to Tufanganj 1 Panchayat Samiti. And thereafter, in the my lord, he promoted to upper division assistant. And my lord, lordship kindly comes to page 16. My lord, he has been transferred from Dinhata to Tufanganj, but his service book was not sent. So, my lord, this is a letter from the executive officer of Tufanganj 1 Panchayat Samiti to requesting to the executive officer of Dinhata 2 Panchayat Samiti. My lord, I am reading. With reference to the above noted subject, this is to inform you that Sri Pramod Chandra Burman, UDA, has been transferred from your Panchayat Samiti and joined this Panchayat Samiti on 18/6/2014 as per order such and such of additional executive officer Kuchbihar Jilla Parishad Kuchbihar, but till date, i.e. 25/7/2019, the original service book of C. P.C. Burman has not been received. You were requested to send the above service book. This is the letter from the Panchayat Samiti executive officer of Tufanganj to Dinhata. Thereafter, lordship kindly comes to page 70. These are the representations of the petitioner to both the executive officer, to Dinhata as well as to Tufanganj.
Yes.
My lord, page 18, his request was, my lord, forwarded to Dinhata 2 Panchayat Samiti by the executive officer of Tufanganj Panchayat Samiti. Thereafter, lordship kindly comes to page 20. This is again a request from the executive officer of Tufanganj 1 Panchayat Samiti to the block development officer Dinhata Kuchbihar. My lord, request for transferring the provident fund.
Yes.
Thereafter, sending here with original applications of Pramod Chandra Burman to take necessary action, please. Thereafter, page 21, again, right to informations by the petitioner. Lordship kindly comes to page 25. This is the order of the Honorable High Court. What happened, my lord? His service book was not sent, but suddenly, my lord, few days, 7 months before of his date of superannuations, a transfer order issued. My lord, my lord, the petitioner approached before the Honorable High Court. Lordship, page 28 is the relevant portion of the order. Here, my lord, the reflection of service book also there. I am reading the para 2. The petitioner, lordship has got it.
Yes.
The petitioner raises the question that he has only 8 months left in his service career, and at the end of the service career, such transfer will only disturb settlement of his federal dues. There is some merits in his submissions, as it has been submitted that the service book and the personal file of the petitioner have not been sent to Tufanganj 1 Panchayat Samiti. I do not find any reason of such transfer. So, my lord, the transfer was set aside. Subsequently, my lord, he superannuated from his service from Tufanganj 1 Panchayat Samiti. But, my lord, even today, his service book from Dinhata 1 Panchayat Samiti
has not been sent.
My lord, page 30. This is the last letter by the executive officer of Tufanganj 1 Panchayat Samiti, that is on 2nd of March 2023. Well, and I am reading the letter. This is to inform you that the original service book part 1, part 2 of Sri Pramod Chandra Burman, ex-UDA Dinhata 2 Panchayat Samiti, along with service related documents, have already been returned to your end by this office now for rectifications of his increment. The said service book has not yet received to this till date. The incumbent concerned in pressing hard for the same, He was requested to kindly rectify the same, return to the end for submissions of his pension papers to the appropriate authority for sanction of pension. So
So
my
it's
lord,
not that it was not sent, it was sent, again
thereafter,
sent back for rectification.
Not, yes, my lord, for that, my lord, he is not getting the pensions and the other benefits. This is my submission.
Yes.
Well, what has happened in this case is that there is some discrepancy in the GPF ledger of the petitioner concerned. And for that purpose, some corrections and updations were required. For the purpose of updation, Dinhata 2 Panchayat Samiti Executive Officer had been specifically asked by the Tufanganj 1 Panchayat Samiti Executive Officer to rectify to
Yes.
update the same service book. But the same updation is still now not happened. By reason of the fact that the earlier executive officer of Dinhata 2 Panchayat Samiti is no longer there. Now some new person has joined the post of the executive officer Dinhata Panchayat Samiti, Dinhata 2 Panchayat Samiti. He has no knowledge about the service of the petitioner. It was not during his tenure that the petitioner
He
served.
doesn't need to have knowledge. The
But-
documents are there, records are there.
What can be done, my lord? Direct the petitioner to approach the Dinhata 2 Panchayat Samiti.
Nothing, no approach. Within 2 weeks, it has to be sent, otherwise contempt.
31st of December 2022.
How long will he keep
Well,
continue to
several
approach?
requests have been made by the present Tufanganj
yes,
Panchayat Samiti executive officer to the Dinhata 2 Panchayat Samiti.
That I have brought to your lordship.
Those are already on
attention.
record. I also have the same instructions. It is to be done on the part of the executive officer of Dinhata 2 Panchayat Samiti, who is sitting tight over there.
Yes, Dinhata has to send it to Tufan.
Dinhata has to
yes.
send it.
So it's the
It's
Dinhata.
the Dinhata 2 Panchayat Samiti executive officer who
So
has to
let
take
the
that.
Dinhata officer be directed
Lordship.
within 2 weeks.
Yes, your lordship.
Affidavit of service. The petitioner was appointed as a clerk cum typist in the office of the Dinhata-Roman 2 Panchayat Samiti in the year 1990 and was brought to the regular establishment in the same year. So the petitioner was transferred to Tufanganj-Roman 1 Panchayat Samiti on 18th July 2014. But his service book and provident fund documents
Yes, your lordship.
and provident fund documents were not sent by the Dinhata-Roman 2 Panchayat Samiti to his subsequent place of posting at Tufanganj.
Tufanganj 1.
Several Tufanganj-Roman 1.
Roman.
Several communications made by the Tufanganj 1 Panchayat Samiti as well as the petitioner in this regard were not heeded to by the Dinhata 2 Panchayat Samiti. Stop. The petitioner superannuated on
My lord, December 31st, 2022.
December 31st, 2022.
Yes, your lordship.
The original service book along with relevant documents were sent to the Tufanganj 1 Panchayat Samiti and sent back to the executive officer Dinhata 2 Panchayat Samiti for rectification of the increment of the petitioner with effect from 1st February 2007 to 1st July 2013. Stop. Despite requests made by the executive officer Tufanganj 1, the service book along with related documents have not been sent back to Tufanganj 1 Panchayat Samiti by the executive officer Dinhata 2 Panchayat Samiti, for which the petitioner is being deprived of his pensionary benefits,
Pensionary benefits,
of
nothing
its
is getting.
pension and other retirement benefits.
Yes, sir.
Stop. The petitioner seeks a direction upon the executive officer Dinhata 2 Panchayat Samiti, comma, being the fifth respondent hearing, comma, to take necessary steps for sending his service book along with other relevant documents to the executive officer, comma, Tufanganj 1 Panchayat Samiti at the earliest. Paragraph upon consideration of the submission made on behalf of the parties, comma, this court is inclined to hold that it is most unfortunate that a responsible authority like the executive officer Dinhata 2 Panchayat Samiti has not cared to send back the service book along with other relevant documents of the petitioner to the executive officer Tufanganj 1 Panchayat Samiti, resulting in deprivation of the petitioner of his legitimate dues after his superannuation. Paragraph in view of the above, comma, the writ petition is disposed of, directing the fifth respondent to send back the original service book along with relevant documents of the petitioner after causing necessary rectification therein to the
Tufanganj, my lord, please say respondent number
executive
6.
officer Tufanganj 1 Panchayat Samiti, comma, being the sixth respondent herein, comma, within 2 weeks from the date of communication of this order. Disposed of also.
I am grateful, my lord.
Paragraph, it is expected that the sixth respondent shall make all endeavors to take endeavors for release of pension and other retirement benefits in favor of the petitioner within 1 month from the date of receipt of the service book and other related documents.
My lord, extremely grateful, my lord.
Disposed of. Otherwise, it will lie there
Yes, yes, yes.
and you have
That
to
is-
come back again.
My lord, I am grateful, my lord, for this addition, my lord.
Next,
Item 9, my lord, I am for the petitioner. I'm produced. My affidavit of service may be kept.
only the state respondents?
Yes.
Not one
This
private
one
respondent.
respondent.
Sir,
There are five. Sir, my lord.
yes, what is the matter about?
My lord, the subdivisional controller, that is respondent number 4, floated an advertisement for the grant of APS dealership license for the district of Kuch Bihar, my lord. If I can have my lordship for a moment at page number 23. At page 23, this is the advertisement.
Yes,
My lord, in pursuant to this advertisement, your petitioner submitted an application. My lordship can find at page number 26. This is the application which has been filed by the petitioner before the respondent authority.
26,
26, my lord.
this is an affidavit.
My lord,
This is the application on affidavit.
my lordship, my lordship.
Yes,
My lord, in pursuant to this application, my lord, they rejected the application of your petitioner without citing any reason, my lord. No opportunity of hearing has been given.
where is the
That-
rejection order?
My lord, there is no rejection order annexed to it. My lord, kindly come to the last page. The license has been given to the private respondent. That is Mr. Ayub Ali,
Page,
77, very last page.
yes, 77. Column,
Column 6 from the top, Ayub Ali. 7, column 6 from the top, Ayub Ali.
6 is Deepak Chandra.
Oh, my lord. Aisha, then Ayub Ali. 32.
Ayubali, yes.
Ayub, my lord. Now, my lord, no opportunity of hearing has been given to your petitioner. That is mandatory provision of Rule 22 of the West Bengal PDS Control Order 2013. If I can have my lordship for a moment, at Rule 22 of the PDS Control Order, what does it says?
There was an intimation of rejection to you? No.
No, they didn't serve any intimation to the petitioner. My lordship, kindly hear.
How did you get this copy?
My lord, I get this copy from the department. Kindly come to the,
Because there is no signature, no authentication.
no, my lord. There
So
is,
how do you know that this is a proper copy or
my lord,
correct
the
copy?
respondent number 5 already running the dealership.
Okay.
Kindly see, my lord, Rule 22. What does it says? Power of the licensing authority to refuse, grant, reissue, or renewal of the license. The licensing authority may, after giving license an opportunity of stating his or her case in writing, and after giving him or her an opportunity of being heard, and for the reason to be recorded in writing, refuse to grant or reissue or renew a license. So, my lord, they deliberately violated the provision and they didn't given any opportunity of hearing to the petitioner, my lord. Even otherwise, my lord, I am squarely covered by a order of this coordinate bench of the Honorable Court where the stay had already been granted, my lord. If I can have my lordship to the order. Kindly come to the page number 2, para 2, second para. It is the grievance of the petitioner that before rejection of the application filed by the petitioner, she was not given an opportunity of hearing, which is mandatory provision to be followed by the licensing authority. It is also submitted by the learned senior counsel that the petitioner was not served with a copy of the inquiry report after inquiry. Thus, it is the case of the petitioner that basic canon of natural justice has been violated while rejecting the application of the petitioner. Now, my lord, last page, last para. There shall be an order of status quo in respect of the license of FPS dealership, my lord. The same case happened here, my lord. No opportunity of hearing has been given to your petitioner, my lord. And they issued the license to the private respondent, my lord. And currently he is running the dealership. The same thing happened in this case, my lord. No opportunity of hearing, no communication, my lord, nothing.
And what about the inquiry? Nothing communicated
Nothing
to
has
you?
been done, my lord, nothing has been.
Let us hear the state.
If I can have my lordship on the notification itself, that is the vacancy notification, that is annexure P, page 23.
Yes.
Well, let me kindly have a look at the point number 2 mentioned in the said notification.
Yes.
Application in prescribed pro forma, form C, along with requisite documents as mentioned in part 4 below, and receipt of deposition of application fee for rupees 1,000 only should be submitted to the office of the subdivisional controller who does apply Zenata subdivision could be. So the primary requirement in order to apply to submit form C, application has to be made in the prescribed form, that's the form C. Well, now let us have a look at the application that has been submitted, allegedly submitted, well, page 20. Annexure P4.
Yes.
Well, this is on the top right hand corner, this is written annexure 1 to form C of WBPDS MMC order
Yes.
2013. This is an annexure. The original form was never filled up by the candidate. The original form was never submitted by the petitioner concerned. Only the documents have been, the payment has been made, the documents have been submitted. These are the documents. These are the documents which have been submitted. The original form C was never submitted, which is mandatory as per the notification.
So it was not considered.
So obviously it was not considered. It was not even considered as an applicant.
Yes. Have you submitted the form C, which is mandatory?
My lord, if I have not submitted the form C, where they have intimated me.
Please show me a copy.
My lord, I didn't annex the form C application. My lord,
have it.
prior rejecting my application, they have to cite it any reason or opportunity of hearing should be given to the
Question of
petitioner.
rejection does not arise. She did not apply in the proper form. Question of rejection will arise only when she applies in the proper form.
This is not an application at all. Where is your form C?
My
Can
lord,
you
the
come
form
back
C
with it?
My lord,
Can you come back with a copy of Form C?
my lordship, my lordship,
Yes, to show that you have submitted
my
it,
lordship,
because it should have been received by the authority.
my lordship, my lordship,
There should be a receipt, seal and all that of the
my
authority.
lordship, my lordship,
So please come back with the, let him come back. Let us see if he has actually submitted.
my lordship.
It is submitted on behalf of the petitioner that pursuant to a vacancy notice issued by the Department of Food and Supplies, SCFS, Government of West Bengal on 22nd August 2022, the petitioner applied for license applied for grant of FPS license before the authority. Stop. The petitioner learned that such license was granted to the private respondent and not the petitioner. Stop. Paragraph. Learned counsel for the petitioner submits that despite depositing requisite fees along with the application for grant of license, no opportunity of hearing was granted to the petitioner prior to rejection of his application. And such rejection was also not intimated to the petitioner by the authority. According to the petitioner, according to the petitioner, the rejection was made in contravention of Rule 22 of the West Bengal Public Distribution System Order
My lordship,
of the West Bengal, the West Bengal Public Distribution System within bracket maintenance and control bracket closed order of capital, 2013. Paragraph. Affidavit of service. Affidavit of service level, none appears for the private respondent despite service. As a paragraph, learned counsel for the state respondents submits that the petitioner did not submit the application in the prescribed pro forma within bracket Form C, bracket closed, mandated by the vacancy notice dated 22nd August 2022. And therefore, the application was not taken into consideration by the authority. Paragraph. Learned counsel for the petitioner seeks to submit a copy of the Form C pro forma on the adjourned date. Paragraph. Let the matter appear under the same heading on, when can you come back? 9th August?
my lordship.
You can take this back, very much. 9th August.
Grateful.
Next.
Deeply obliged.
Yes.
Under
Your affidavit?
unprecedented circumstances, the petitioner is before this court of equity.
Where is your affidavit of service? It's only Bharat Petroleum Corporation.
Yes.
Who is appearing for Bharat Petroleum? You're appearing?
I am appearing for Union of India.
What about
Not
Bharat
answering this one.
Petroleum? Who appears? Mr. Ghosh? You appear for Bharat Petroleum? You're.
Yes.
Yes.
My lord, under an unprecedented situation, the petitioner is before this court of equity and starving for the last 410 days without any speaking order. My lord, the petitioner is a dealer of a petrol pump owned by Bharat Petroleum Corporation. And that petrol pump is totally automated, which is under surveillance of the respondent number 2 corporation 24/7. Any act done in that petrol pump is being surveillanced by the Lordship. I draw your Lordship's kind attention to page 69. That is annexure P8.
Yes.
Now, the petitioner was so caused on 17/7/2022. And if we come to page 73,
This is 19th October 2022.
yes, 19th October 2022. And if we come to page 73 of that show cause notice,
Yes.
we find under irregularities, under the heading irregularities,
Yes.
we find that the petitioner had been allegedly done these irregularities in the outlet. Now, what are the irregularities? I read it out. RO speed tank sample failed to meet the requirements of speed motor gasoline BSVI WRT density at the rate 50 degrees centigrade and distillation parameters of E7 and so and so. That is, my density of the product failed. In 2, ROMS tank sample failed to meet the required of motor gasoline so and so as per so and so latest version. Furthermore, there were variation between density observed. That is failure of the density. Now, third is dealer had not retained TL2 samples of MS and HSD and speed. That is, I didn't upkeep my record. Now, these are the irregularities which were found on 17/7/2022 by the mobile respondent number 5, your lordship. Now, what are the cause? What made them to find this irregularity? Kindly come to page 75 of that show cause notice.
Yes.
Now, page 75, clause 9. ATG product movement data and day-wise product-wise reconciliation report from RO automation were taken, which corroborates the following. Now, on 27/2/2022, as per ATG data, this 8 KL HSD was decanted into speed tank, and thus the product of speed tank got contaminated. That means on 27/2/2022, 8 KLs of HSD, that is high-speed diesel, were wrongly decanted into the MS, that is petrol tank. Now come to the next page, page 76, under clause 12.
Yes.
On 26/22, as per ATG data, 10 kiloliters of HSD was decanted into speed tank again. So there was a mistakable decantation of HSD into the MS tank. So this was the cause which prompted the respondent number 4 to issue this show cause notice. Now this was, this happened on 2 dates, that is on 27/2/2022 and on 26/2022. And the inspection was carried on 17/7/2022. Just look at the dates. And I was show caused on 19/10/2002. Now, in the penultimate para of that show cause notice, if we come, that is, they have the respondent number 2 has said in page 76, Your Lordship, breaches committed from the above, it is clear. Now, 1, 2, 3, 4, 5. There are altogether 9 breaches which was committed by the petitioner. But what concerns us is 2 things. That is, I decanted the HSD into the speed tank, that is MS tank, and I pumped it out from that tank. This is one. And the other is I did not maintain proper record. It is my humble submission.
There are other allegations also.
Yeah, but those will not come into, I will just come to that point. Now, if we come to page 75 again, to para 9 and para 12, one thing comes, it's crystal clear that the occurrence that happened on those 2 days were monitored by them through the ATG data. That is, as the petrol pump is an automated one. Had that act been an irregularity, what made them, what prompted them to sit idle for so many days and to conduct the lab test and thereafter to serve me a show cause notice after 3 months or so. Now, if we see at this show cause notice, 4 things each is be like anything, Your Lordship, and that is very reasonable. Now, from 9 and from 12, we find that the occurrence happened on 27/2/2022 and 26/2022. So the first occurrence was in the month of February, the second was in the month of June. Now, kindly, I take Your Lordship's kind attention to page 73 again, once again. Under the heading irregularities, we find that after a lapse of more than 141 days from the first decantation and 27 days after the second decantation, the respondent number 5 conducted the mobile lab test in the outlet. So the question is, if at all that is an irregularity on my part, what makes them, when it is within their knowledge, what makes them to wait for 141 days and 26 days to conduct the mobile test? Now, another thing that comes is, if we come to page 69, the date is 19/10. I was show caused on 19/10/2022. Your Lordship, after 244 days of the occurrence of the first decantation and 120 days of the second decantation, I was show caused. Is it an irregularity? If at all it is an irregularity, what prompts you to serve me with a show cause notice after so many days? Now, the third question is, the fourth and the most important question that comes to my mind is, at this juncture, is that this entire activity was within the knowledge of the respondent number 4 and the authorities of the respondent number 2 corporation. So if it was at all an irregularity, why this delay? Now, the thing is this, on 17th, when the mobile lab was there, posted in my outlet, and the samples were drawn and tested, from that day, I am under suspension of sales and supply. The pump is closed since 17/7/2022. Now, I draw your lordship's kind attention to page 147.
Yes,
That is the reply that I had given against this show cause notice. Come to page 149.
yes,
Now, under para I have said the retail outlet is also an automated one. Hence, the outlet is controlled, monitored, and is under your active surveillance 24/7, which could be noticed and admitted by you from your ATG movement data as reproduced in your subject noted letter. That is clause 9 and 12, where they have admitted that from the data we have observed that on such and such date, such mistake was done.
yes,
Now, kindly come to page 149, clause L and M. It is true, it is my allegation. It is true that twice your logistic personnel, that is the logistic personnel of the oil company, because this oil outlet is owned, maintained by the respondent number 2 corporation. Your logistic personnel had wrongly decanted high-speed diesel, a product of much less value, in the motor speed underground tank, a product which is much costlier, thereby causing huge financial loss to me. As both the products lost its original identity, this amply proves my innocence and my mind to be without malice, because of the fact I did not sell the decanted HSD in the MS speed underground tank in lieu of MS speed, which is also admitted by you in your subject noted letter. Now, please come to M, the next page, 150.
yes,
On the first occasion of such wrong decantation, the same was reported immediately to your sales officer, Mr. Roshan Patnaik, by me in presence of your logistic personnel right after such wrongful decantation by your logistic personnel at about 7:22 p.m., which could be well ascertained from the mobile call data. Now come to, I draw your lordship's kind attention to N. In order to camouflage the wrong committed by your logistic personnel and to safeguard them, it was Roshan Patnaik who, in consultation with Mr. Suvendhu Roy, mobile number so-and-so, and Mr. Praveen Kumar, and with your authorized contractor, advised us to pump out the HSD from the MS tank and to decant it in the HSD underground tank, and the MS speed product being of much higher grade, it shall cause no harm to HSD. Rather, it will enhance the performance of HSD vehicles, because petrol is much more of the higher grade than the HSD. They said that if petrol is contaminated, HSD will have a efficiency in performance. Now, I specifically draw your lordship's kind attention to this. Be it on record that the entire pumping out process was carried out by your authorized contractor under the active guidance of Mr. Roshan Patnaik, Mr. Suvendhu Roy, and Praveen Kumar, who are the respondents in this case. Now, I draw your lordship's kind attention to page 152. After receipt of this letter, the respondent number 4 has not denied these facts. He haven't denied a single fact. The decantation, wrong decantation was done by their logistic personnel. It was pumped out by them. They haven't denied. Now, instead, what they have done, they have asked from me to furnish proof or evidence to that effect. Now, I draw your lordship's kind attention to para 1. Under point 1M of your reply, you have alleged that on the first occasion of wrong decantation by logistic personnel, you had reported the same immediately to the sales officer, Mr. Roshan Patnaik. You have under point 1N further alleged that Roshan Patnaik, along with other territory officers and the authorized contractor, had advised you to pump out the HSD from MS tank and to decant it to HSD underground tank. You have also mentioned that the pumping out process was carried out by our authorized contractor under the active guidance of Mr. Roshan Patnaik and Praveen Kumar and Mr. Suvendu Roy. You have alleged that this was done to camouflage the wrong committed by our logistic personnel and to safeguard them. You have further alleged that the same instructions were conveyed to you during wrongful decantation of HSD into MS tank by our logistic personnel for the second time.
The allegations have been recorded and you've been asked to produce evidence.
It is my allegation, but they have not denied. Now I come to para 2. Under point 1Q of your reply, you have alleged that our committee members opined in public as Gadha se hal nahi jota jata, which means one cannot plow a land with a donkey as you belong to a scheduled caste community. Number 3, under point 1N of your reply, you have further alleged that after receiving the show cause notice dated so-and-so, you had contacted Mr. Roshan Patnaik, and he, in presence of the public in the retail outlet, reciprocated with humiliating words as scheduled caste ke buddhi lekar outlet nahi chalaya jata. Where is the denial? Now he asks to give me a proof. Kindly come to page 1.
They have not dealt with your reply at all
Yes.
till this stage.
Kindly
They
come
have
to.
asked for evidence.
Yes. I draw your lordship's kind attention to page 154.
Yes.
My reply. I am happy to note that you have appreciated my explanation as sought for, and thereby admitting clearly no act of wrong was ever committed by me as purportedly alleged in your show cause notice barring these clauses. It is true that wrongs as committed by your officials are stated in my reply in para 1M, 1N, 1Q and 1R are not only serious in nature as admitted by you, but it is also against the spirit and principles of Constitution of India. Hence, I reserve my right to agitate on the same before proper forum, unless those are addressed by you by taking necessary action as prayed for me in my reply dated so and so. That your request for furnishing evidence before yourself towards what has been stated by me in para 1M of my letter dated so and so, I had already intimated you that the mobile data of the phone numbers of your officials and my number shall speaks for itself. That your request for furnishing evidence before yourself towards the offenses so committed by your officials as stated by me in para so and so is against the doctrine. No man can be the judge of his own cause. Now, he is asking from me the evidence to be produced before him that the words that they have used, he wants to be judge of his own cause. I'm not coming to all these things. Now, if we come back to the original state, that is, their grievances, that is non-availability of reference density at the time of inspection, that is page 109. Stock variation of MS and MD and non-maintenance of specified records. I draw your lordship's kind attention to page 78, your lordship. That is annexure P9.
Yes.
This is the marketing discipline guideline, which is followed throughout India, pan-India. In case of any breach or irregularity is committed within the RO premises, the oil companies take actions against that dealer as per this marketing discipline guideline, which is being formulated by the respondent number 1 here. Now, my offenses were that on testing of the product, the density failed. The density was not within permissible limit. Second was, I didn't maintain proper books of record. Now the offenses are, the irregularities are dealt in chapter 5, that is page 106. I draw your lordship kind attention to page 106.
Yes.
That the heading says type of irregularities at retail outlets, MSMS and SKO LDO dealers. Now, non-availability of density is dealt under clause 5.1.9. Please come to page 109.
Yes.
Non-availability of reference density at the time of inspection. The dealer is required to check and record morning density on the daily basis. This has to be carried out latest by so and so, so and so, so and so. I'm not taking much time of this honorable court. I'm not reading the entire. Now, stock variation, that comes under 5.1.11, that is page 110. Stock variation of MS and SD. Details are there. Non-maintenance of record, that comes under clause 5.1.12, that is page 111. Now, if these irregularities, say, assuming but not admitting that I have done, say I have done, what is the penalty? Now, the action is dealt under chapter 8. That is page 120. Chapter 8, action to be taken by OMCs under the marketing discipline guideline. All irregularities are classified into 3 categories: critical, major, and minor. Now come to major irregularities, 8.3. We are concerned with second one. Non-availability of reference density at the time of inspection. Right? We are concerned with 4. Such stock variation beyond permission limited but sample passing quality test. Right? We are falling under 5, non-maintenance of records since last inspection. Now, assuming but not admitting I have committed these offenses, so I will be dealt under 8.3 clause 2, 4, and 5.
Critical irregularities also.
Yes. What are the punishments? I will come to all I will satisfy. Now, what are the punishments? Except of 3, 7, 8, 9, and 10, that is, I am falling under this. On the first occasion, my punishment is suspension of sales and supplies of the outlet for 15 days. And if I commit for the second time the same irregularity, my outlet will be suspended for 30 days. And if I commit for the third time, my dealership will be terminated. Your Lordship, thereafter what happened? It is instead of suspension of the sale of supply at the most of 30 days, assuming but not admitting if I have committed all these irregularities, at the most my suspension will be 30 days, but I am reeling under the suspension of 410 days as of this date, that is 2nd of August 2023. Now, why I am harping on this? Your Lordship, kindly come to page 124. Clause 8.5.8. This is the vital thing, and this
Where is the penalty for critical irregularities?
that is termination.
Only termination.
Termination. No first chance, second chance. Now, 8.5.8. Upon receipt of the reply to the show cause notice. This is very important. Upon receipt of the reply of the show cause notice, the authorized officer of the OMC will review the charges leveled and the reply received and pass a speaking order preferably within 45 days from the receipt of the reply. The speaking order shall indicate complete details of the irregularities committed, the reply of the dealer, and details reasons as to why the reply is acceptable, not acceptable to the official. Now there is a time frame of 45 days from the date of receipt of my reply to pass a speaking order. Where is that order? Thereafter, what happened? After receiving my reply, kindly come to page 157. He advises me, the respondent number 4 advises me to appear for a personal hearing on 20th of January 2023.
154.
Yes, 157. This is annexure P13. Personal hearing on 21, 2023.
Yes.
I attended that personal hearing. Now, if I take this date as of a cutoff mark, even 7 months have passed, no speaking order has been passed. This is totally arbitrary, monarchy attitude on the part of the authorities of the respondent number 2 corporation, your Lordship. And I'm reeling under starvation for the last 410 days without assigning any reasons or whatsoever. The natural justice of the entire thing has not been dealt with. Now, in a nutshell, if you see what happens, on 27/2/2022 was the first decantation. On 20th/6/2022 was the second wrongful decantation. On 17/7/2022, that is after 141 days of the first decantation and 27 days of the second decantation, the mobile lab test was done. On 19/10/2022, that is after 244 days after the first decantation, wrongful decantation, and 120 days after the second wrong condition, I was so caused. Within 12 days, I had submitted a reply to them. The respondent never denied. Instead, asked from me to give evidence to those replies, and I cannot pass on any information to be a judge of his own cause, to a person who is the judge of his own cause. Now, on 4/1/2022, letter for personal hearing was done. On 20th, the personal hearing was undertaken. Now, clause 8.5.18 clearly says that after receipt of the reply of the show cause notice, within 45 days, it is a mandate. Within 45 days, you will have to pass a speaking order. But what is the result? They have not passed any speaking order. Instead, I am under starvation for the last 410 days. Your Lordship, under these circumstances, the outlet being the only source of my livelihood, not only my entire family, the staffs of my outlets are also under starvation. And where the rule says that the maximum penalty is 30 days, for 410 days it is under suspension. Your Lordship, I am relying upon one judgment of the Honorable Supreme Court, reported in AIR 2010, Supreme Court page 336, Your Lordship. Settle law. Here the Union of India went for an SLP. There was an indefinite suspension, and the rules mandated that within 90 days, the matter has to be sorted out or reviewed. That was not done. The Supreme Court, what the Supreme Court says, having carefully considered the submissions made on behalf of the parties and having also considered the relevant dates relating to suspension of the respondent, and when the petitioner's case came up for review on 20th October so-and-so, we were inclined to agree with the views expressed by the Central Authoritative Tribunal as conferred by the High Court, that having regard to the amended provisions of the sub-rule 6 and 7 of Rule 10, the review for modification of revocation of order of suspension was required to be done before the expiry of 90 days. In our case, it is clause 8.5.8, where it is mandated within 45 days, you will have to pass a speaking order after receipt of my reply. My reply was on 1/11/2022, and today is 2nd of August 2023. 2 months and 7 months, 9 months, they are sitting idle over the issue. They have not passed any speaking order. My Lord, under these circumstances, I pray that an ad hoc order should be passed. An order of injunction till disposal of rule directing the respondent and each of them to supply the petroleum products to my dealership so that I can maintain my family and the staff of the outlet, Your Lordship. Obliged, Your Lordship.
Yes, Mr. Ghosh.
But the judgment which has been placed before your Lordship,
Take the microphone, please.
the judgment which has been placed before your Lordship, it's pertaining to Central Civil Service rules. For a particular timeline is there. Now, today, Millard is considering a matter where Millard admittedly, Millard, the order terminating the operation of the retail outlet was
Not terminating, it's suspending.
suspending Millard, the functions of the retail outlet was passed on 19th of October 2022. 19th of October 2022. Millard, from October, we are now Millard in August 2023. Now Millard would kindly turn to the agreement. That is the dispensing pump and selling license, the agreement which governs the jural relationship of the petitioner with the corporation. And Millard, particularly, Millard, my service copy is not properly paginated. Millard, I am referring to clause 19A. 64, page 64. আমি বলছি আপনি
No, 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 page number
64, Millard, probably Millard, clause 19A.
Clause
19A.
Yes.
Millard, any disputes or difference of any nature whatsoever, Millard, a very clear and distinguishing arbitration clause is in existence. Now,
Mr. Ghosh, you are aware that despite existence of an arbitration clause, a
Yes,
writ petition is
yes.
maintainable.
yes, now Millard, even under the marketing discipline guidelines, there are several hierarchy of authorities before whom we can approach. There is an appellate authority in place. Now, Millard, today, what is the purpose of this writ petition? It is for resumption of sale. And Millard, what can be the ground? Millard, if a resumption of, if the sale is resumed, that tantamounts to Millard interference with the decision of the corporation of a purported termination which is under contemplation.
Have you taken a decision at all?
No,
So where is your decision? That
But
has
that
to
can
be
be
taken
taken.
within 45 days.
Millard, that can be taken within another 7 days. Millard, now kindly consider subsequent to the show cause, replies are coming. It's not a composite reply that they have submitted. There is a reply, then another set of counter allegation.
No, no, after that part was over,
Millard,
I think it's page 120, where a final hearing was taken.
Millard, my copy
Uh,
120, Millard, is something else.
So 120 is the action taken, is critical irregularities.
Yes,
Personal
that is-
hearing was done,
157.
conducted on 21/2023,
Yes,
It's page 157.
157.
yes, 157, the personal hearing was conducted on
So there's a
20th.
mandate of 45 days.
Yes. yes.
Even if we take the initial point to be 20th January when the hearing was held. Long
Millard,
after
Millard,
45
allow us
days.
7 days to pass,
How
Millard,
can it-
to record a decision. 7 days, since it has, Millard, the personal hearing January. 45 days takes us to at best March, first week. The
And we are
petitioner
in-
has approached your lordship in August. So Millard, there is delay on our part also. Millard, I admit to that. Millard, grant us 7 days time to come to a final.
Till
to
7
conclude
days, let the pump
proceedings.
be opened. Let the supply be made. I will see the end of this arbitrary and monarchy action of the corporation.
Millard, what he will. say
And
that-
my, and
No, no,
and my
what
learned
does that-
friend is very reasonable, prudent. He will agree to, with me
No,
to
Millard,
one point,
Millard,
if there is a mandate to be passed, a speaking order to be passed within 45 days from the date of reply of the so-called notice. If I don't go to that also, even after the personal hearing, it's 7 months has gone.
Millard, let him show that a delay in not communicating a decision vitiates the entire process. One
This
judgment,
is-
Millard, I will. go
This
down
is,
to it.
we are standing before a
Millard,
court of equity.
It does not vitiate anything.
We are
At
standing
best.
before
Well,
a court
then
of
I suggest you have suffered for 400 odd days. So
It cannot be, I mean,
please wait for another 7 days.
your
Let the
lordship,
authority take a decision.
Your
Let us
lordship,
see what
yes.
decision is taken.
Yes,
what they will do now, the deed is filed, he will terminate me. He will terminate me.
There has to be a final decision.
What is my humble submission? If we take his, Mr. Das's contention also, okay, let an order be passed to supply the material for 7 days.
No, no, that cannot be done. Because there are serious allegations which
Your
need to be
lordship,
dealt with.
lordship, there is a mandate of 45 days. That is
Maybe.
gone.
Maybe.
Why I will suffer?
Millard, that guideline of 45
You
days.
have actually not made your submission on the critical irregularities part, which includes adulteration of MS and HSD.
Yes,
You have,
but your lordship,
so that is one of the allegations against you.
But they haven't, what makes them to sit idle? My love, my simple question is, if that is at all an irregularity, what makes you to send the mobile there after 126?
I'll record your submission. Give 7 days to the respondents to deal with it.
Yes,
Otherwise necessary order will be passed.
yes. No difficulty.
Now within 7 days, I know what will be the fate.
A decision has to be taken when a hearing has been held, isn't it? Merely because of the
But there is a-
delay, a decision cannot be
That I should be,
uprooted.
I should be also protected. Okay, 7 days time, fine. But that will not, such decisions will not, you
A
know.
protection for 7 days will not really inure to your benefit.
No. What I am saying is, suppose after 7 days, suppose, for example, all it's and but. Say after 7 days, the respondent number 2 corporation terminates. What happens to this return?
Millard, there is a,
This is
there is a,
infrastructure.
Millard, there is a
This is.
There is a
infrastructure.
clear alternative remedy to that. He has an
I
appellate
will
forum.
not go to
Yeah.
you.
He has
Why
an,
should I go to you when for your mistake?
it's a
If the
preferred
law-
arbitration.
If the law,
No,
yes,
no,
Millard, you
that
can
is a
prefer
separate cause of
arbitration
action,
proceedings.
isn't it? That's a separate cause of
Yes,
action.
no. So, at least some protection must be there.
At this stage, I don't think that is possible, sir. I'm sorry. Affidavit of service. Paragraph, heard learned counsels for the parties. The paragraph.
What can I do?
My lord, I will not irritate you for the second time. My only point is there was a mandate of 45 days. Now, that was not complied. Am I not entitled to get the protection from this court of appeal?
Only,
That's all.
only because of the delay? I don't think so. We have to be on merits also.
I have shown if there was a.
Because one
denial
of the
from their-
allegations against you is a critical irregularity.
If there was a denial,
Uh,
they haven't said so in their show cause notice. If we read
Yes,
the entire. show cause
Adulteration of MS and HSD is
yes,
is one of
in
the
the-
allegations.
In the show cause notice, they have not whispered a single word of adulteration.
Maybe the word has
mistake.
not been used, but
How-
what they have said is adulteration.
And that has been done by their personnel because this pump. is
That
a-
has to be substantiated.
Is an inside pump and it is owned, maintained and serviced by the respondent of 2 companies.
No, wrong.
Their logistic personnel. has
These
been
are all
done.
disputes of fact which need to be substantiated.
I do agree, but it is also,
It requires evidence, in fact.
it is also a mandate. Within 45 days, you will have to pass a.
And that's
order.
the reason why there's an appellate forum who can record evidence and deal with the case,
Yes.
which the writ court cannot do.
Cannot.
There are complicated
Now,
questions of fact here.
now the thing is this, what will be the fate? I can judge it.
Initially, I was of the view that the writ court cannot deal with it. It has to be relegated. But then as a decision has not been taken as yet, let the authority take a decision before relegation.
The authority has only one decision to be taken. that
Yes.
is to
So
terminate it.
you'll have the appropriate forum after that. There should be a decision.
Anyways, oblige. you.
The petitioner has been running a retail outlet a V-Day letter of intent issued in his favor on 2nd December 2005. By the 4th respondent, letter of intent.
Only thing is that I have not gone into the entire rate. If you see I have been, your lordship, what happened with me, না না আর কিছু বলছি না রে বাবা বিক্রম বাবু, why should I? (24/9/2004) was the advertisement.
Yes,
I was handed over this very petrol pump after on 23/4/2019. That is after 15 years. That time also this petrol pump was a closed pump. And it's in my read. See, I was handed over a closed pump. I, of my own initiative, had mutated the name, has changed the classification of the land. Thereafter, the pump was open. আজকে আপনি from 15 বছর পরে আজকে I was given this dealership, and after this আপনার your lordship, there annexure come to annexure.
this is not within the purview of the present writ petition.
I know,
sir.
I know, I know, I know.
So let me pass an order, please.
68, page 68, আপনি একবার once.
Yes,
For rendering that service to the corporation, I was awarded the best dealers award.
is that very relevant in the writ
No,
petition?
I'm not saying so. I'm not saying so. But I was for 15 years from the date of advertisement till appointment. My appointment was delayed. Thereafter this, some protection I seek, your lordship. Some protection.
Show cause notice. Stop there. A show cause notice was issued upon the petitioner by the respondent authorities on 19th October 2022, alleging certain irregularities. The petitioner replied to the show cause notice on 1st November 2022. Following which, the authority, by a letter issued on 29th November 2022, requested the petitioner to submit relevant proof/evidence in support of the allegations made by him in the reply to the show cause notice. Stop. In reply, the petitioner by a letter issued on 9th December 2022, submitted that the authority had no cause/authority to issue the letter dated 19th October 2022 Stop. The petitioner refrained from furnishing any evidence before the authority on the anvil of the doctrine, inverted comma mode, no man can be a judge of his own cause. No man can be a judge of his own cause. Stop, inverted comma closed. The petitioner requested dropping of the arbitrary proceeding and resumption of sales and supply of the outlet. Stop. The petitioner was called for a hearing by the authority on 20th January 2023, which was attended by him. Stop. Paragraph. Learned counsel for the petitioner submits that despite, where is the mandate of 45 days in the rules? At page
5.8. Page number,
124. Yes,
page 120.
submits that no speaking order has been passed by the authority pursuant to the hearing, despite mandate laid down by the marketing discipline guidelines laid down by clause, laid down by clause 8.5.8 of the marketing discipline guidelines, which indicates that upon receipt of reply to a show cause notice, comma, the authorized officer shall review the charges leveled and reply received and pass a speaking order, preferably within a period of 45 days from the receipt of the reply. Learned counsel further submits that though the alleged irregularity was detected on 17th July 2022, comma, the lab test was held after inordinate and unexplained delay by the authority. Stop. Learned counsel further submits that he may be allowed to resume service in order to save his family as well as the staff of the outlet from starvation, since the outlet is the only source of livelihood for them. Paragraph. Learned counsel for the respondents seeks a week's accommodation to pass a reasoned order in respect of the hearing held on 20th January 2023. Paragraph. Let the matter paragraph in view thereof, comma, who should pass the reasoned order?
Let the territory manager.
Respondent number
4.
The fourth respondent is directed to pass a reasoned order
If Millard kindly
Do you,
records,
yes,
Millard, since it's a critical irregularity case, Millard, probably Millard, the general manager will, Millard kindly records competent authority of the respondent corporation.
in view thereof, comma, the competent authority of the respondent corporation is directed to pass a reasoned order with regard to the hearing held on 20th January 2023 within
9th of August.
within 9th August 2023 and communicate the same to the petitioner within 2 days thereafter,
Yes.
within 11th August 2023.
এটা একটা
Yes,
option opportunity prior to
opportunity of hearing was granted. You
Yes,
need a
yes.
further opportunity?
yes.
You
The
need a
personal
further
meeting is
opportunity?
already concluded. Let the meeting says, note says that it is already concluded, the personal hearing.
Give a further opportunity of hearing if
But then can we
necessary.
extend the time also, Millard, because in 7 days time, Millard, we have to communicate him, he will go represent himself, submit documents, we have to consider that.
You don't require a
No,
hearing.
Not at all.
Next circuit, in that case.
Millard, keeping the petition pending. I don't
How
think
can it,
Millard-
how can it be disposed? of?
Yes, let him he'll come back with the
Grateful,
report.
Great.
Come back with the order.
Millard, any,
Paragraph,
as
the
Millard
matter will be
desires.
placed before the next available circuit bench.
Grateful.
Monday again, a circuit starts. It's a continuous circuit now, so it will not be difficult. They took two wedding. The next circuit is out.
August.
The next circuit is out. যেগুলো আমার hearing complete হয়েছে না, সেগুলো তুলে দেবেন লেখাতে। Yes, next matter.
Yes, but I am for the petition. Relating to interest and gratuity device so far 2009.
Served.
Yes, but I have that.
Who is appearing? Mr. Shah, you are appearing?
No, it's actually given to someone. Yes.
Yes, Mr. Shah, you are appearing. This one.
Yes, ma'am, I'm representing.
Let a similar order be passed. Interest and gratuity. Affidavit of service. Properly similar. You have checked the order?
Yes.
Next.
Single video, only one.
I beg to
appear for the state lordship.
Yes, let a similar order be passed.
Yes, lordship.
She's the widow. Next.
Yes. Single video.
Service. Who is appearing? Mr. Who is appearing? 14, yes. Please give your name. Single PPO. Single.
Single video.
State.
Similar matter.
15, next. Huh? 14.
Lordship, I beg to appear for proceedings.
Yes,
Device 19.
revised.
Petitioner. Person is a employee.
Yes, same order.
Yes, Lordship.
Device. 17 device.
I'm for the statement.
17.
State, you're appearing.
Yes, ma'am.
Same order, revised
Eh,
PPO.
Ending single pure. 18 matter, I am happy with it.
Same order, Mr. Shah.
Vale. Thank you.
Petitioner 19. Anyone for the petitioner in 19?
It's not a pension gratuity matter.
No,
Different matter.
petitioner is not there. None appears for the petitioner. No accommodation is sought. Paragraph, let the matter appear before the next available circuit bench. Same order.
Yes, I'm for the.
I'm for the state, Lordship.
Yes.
The double PPO device 2009.
Oh, again PPO.
The argumentation is a group step of the life.
What is a cycle peon? Cycle peon? The designation is cycle peon. Yes, next. This was.
Yes, but I'm for the.
I'm for the statement.
Then Revised 2019, the librarian of the life.
State,
I'm for
you're appearing, same order. State,
Lordship.
revised PPO, same order.
Revised PPO.
24
I'm for
state,
the
you're
state,
appearing.
Lordship.
Librarian revised 2019.
Same order.
Yes, madam. I'm for the statement.
Revised 2019.
Live.
Same on. Respondents? Service affected?
Yes, my lord. The GST matter, most probably Mr. Ghosh will appear. I am appearing in both the matters.
26, 27.
26, 27, but I am paying only 1 day's accommodation. I have received the instructions yesterday late night. I cannot go through.
Not today.
Not today, my lord. Tomorrow,
27, I am.
Both the matters not today.
yes, 26.
Hmm.
Okay.
28, yes. Weekend. Weekend. Will not continue.
Tomorrow, High Court is.
Busy man. Yes, respondents?
Actually, just now I have been informed, actually, I'm appearing on behalf of the respondent.
Yes.
Well, thinking-
You received copy.
Has been served long time back on the West Bengal Forest Development Corporation
Yes.
on the 27th. It has been served.
But it may be the fact, but I have been informed just few weeks back.
That is not there.
I'm appearing today, Lordship. I'm appearing today.
He needs instructions, sir.
I
Please come
need
back.
instruction, Lordship.
And that even
Just now
I
I've
will
been-
not proceed with something, I'll be paying for an interim protection. There
Please.
is something, which is
Can you
going-
come back tomorrow?
Yes, Lordship.
Tomorrow,
You'll not be there.
not possible.
You'll not you can appear virtually also.
No, but virtually,
I'll allow. If you can, I'll allow.
if he, may I just place the issue just for 2 minutes so that he also understands what we are on. This is pertaining to the functioning of this ropeway in, Darjeeling. This ropeway, the allotment was made, in 1997, 1996, the formal commencement took place from 1998. Rightly, wrongly, this is continuing. From 2003 till 2011, the ropeway could not function owing to an accident, and the term was initially for 20 years. Now, we moved your lordship's court, Justice Dipankar Datta, in 2016 said that it is to continue till 2018 because, the commencement took place from 1998. So 2018. In the meantime, there was again, certain issues raised, again, we approached your lordship's court, Justice Bagchi came to our rescue, and ultimately, the ropeway, by virtue of a modified agreement, of 2018, it is continued. The agreement is to expire in terms of the 2018 third agreement, it is to expire in the month of December 2018. That is the sum and substance. 2023, sorry, 5 years. Now, there are 2-3 clauses which say, that the period for which, during which the ropeway cannot function owing to force majeure clauses, it has to be extended. 1. 2 is, there is an analogous clause that if an approach is made to my learned friends' clients at least 6 months prior to the end of the term, then they are going to suitably consider my extension. For another, I have been agitating this extension issue from 21. Just for my learned friends' assistance, from 2021, after this COVID, when the ropeway restarted, there is one document, very early, last 5th of July, which the periods are indicated that during these last 5 years when we could not operate owing to COVID, precisely COVID, and for a month, because of one particular NOC. Now, everything is in order. This is, we are praying precisely for an extension by at least.
And the ropeway is functioning now.
Yes, yes. Functioning, they have permitted it. But the funniest part is, they have a right to invite bids. But, in the teeth of existence of an this application for extension and on justified grounds and in terms of the provisions enumerated in the agreement, and
Also considering the fact, my lord, that from 2003, my lord, I cannot agitate that, but the fact remains, my lord, 2003 to 2011, my lord, admittedly the ropeway could not function because there was a huge, my lord, accident which had taken place, my lord, at the material point of time then. Now, my lord, I will be humbly beseeching my learned friend. We'll come back next week. My lord, I'll be humbly beseeching you, my lord, my learned friend, to come back at least with this instruction as to what they, because, my lord, there's a tender which has now been invited. My lord, I have not participated in the tender. I have asked for, my lord, stopping the
Extension.
tender process because my extension application and everything is on
pending.
record. And that extension application, my first of such application is February 2021. It is on record. Now, my lord, I will be humbly beseeching your lordship. My lord, first is, let my learned friends come back. My lord, the tender is opening on the 14th. We have time. My lord, it is my duty. My lord, I cannot be, my lord, I cannot come back, my lord, in this next 2 days. But definitely, my lord, next week, your lordship will kindly fix, my lord. I'll arrange my roster there and I'll come.
When can you come back?
My lord,
I'll fix it.
more convenient.
Because he is here, I think. So,
My lord,
so when will it be convenient for you?
Just now I received the copy.
Monday?
আপনার সুবিধা বলুন আমার সুবিধার ব্যাপার না আপনার মানডে কার
Not
মানডে
Monday.
no not Monday
So Tuesday or Wednesday?
no,
Tuesday.
Wednesday
Wednesday?
I'll try to come on Wednesday
Wait.
9th
Wednesday is 9th,
Ninth.
right? So let
Ninth.
it be on 9th.
and in the meantime they are going to accept the bids but the opening is on the 14th. The last day for
Not
submission
so
is
the no
14th
interim
within
order
now.
is necessary, yes.
But kindly also
Let
protect
him come back, we'll deal with it next week.
kindly
You have some time with you, so let him
Yes.
come back. Yes. Affidavit of service.
kindly seize my
Paragraph.
first application just for your lordship's gracious consideration 128. First I show your lordship just for your lordship's
Why don't you show this to me on the next occasion, please? Mr.
as whatever.
Come back on that. I'll deal with it. On paragraph on learned counsel for the respondents seeks to take instructions in this matter. Paragraph, let the matter appear under the same heading on 9th August.
9th August.
Please
Well,
be ready. On the next day. That has to be filed in the department, I believe.
And all parties have been served, including the tender inviting authorities of Siliguri.
I find only he's there. There's no other
He is
counsel.
representing all the respondents perhaps. Yes, they are the only
Only the
respondents.
forest, yes, that's, yes.
You know,
So
they
you're
are the only respondents,
right, yes. That's what
I think my learned friend is representing 1, 2, 3.
Actually, I have to see it.
Right?
all the
They cannot
respondents,
be-
in fact, all the respondents.
I'm all them. Great,
So please come.
great.
If you also kindly seize the order passed on 28th September 2021.
Respondents?
They
Respondents?
appeared on the last occasion.
Mr. Shah is appearing and
Mr.
Mr.
Shah.
Ghosh also.
If you also kindly seize the order passed on
28th.
28th September 2021. Along with this matter, attend over 30 and 54 or analogous having similar prayer manner. Yeah, 30, 54. And a person to this direction.
Yes, so has this been complied with?
Partly complied, my lord, till 2020, DA, admissible DA has been paid, my lord, but thereafter, nothing has been paid, my lord. But there are other reliefs also, my lord, prior to that, if you also kindly comes to page 61, annexure P5. This is the second round of writ petition. In the first writ petition, there was direction to consider my representation, my lord. My lord, pursuant
Yes.
to that, hearing was accorded, my lord, and page 68 is the order sheet, my lord.
This order is, it has a very clear and specific direction.
Yes, my lord.
So there's no other option but to follow it.
Yes.
Comply with it. Yes, Mr. Ghosh? Next week. You've seen this order. It has to be complied with in its true letter and spirit. Because your secretary has already escaped a first contempt. So next time it will not be that easy. Principal Secretary, Finance Department was directed to release all the funds.
Yes.
And the Animal Resources Development Department was directed to disburse it. Within 45 days, the entire exercise. So both of them are under scanner. So please ensure complete compliance, please. Otherwise, a harsh order again has to be passed. Come back.
Item number 30 and 54 similar.
30 and 54. 54 is a hearing matter.
Similar matter. It has come to a hearing. I don't know why, but it is similar matter, my lord.
I don't know, 30 I am from state.
30. This is 30.
All are related to the same service and similar
Oh,
prayers.
this is 29.
Yes.
On prayer, learned counsel for the respondents seeks accommodation to ascertain whether the order passed on 28th to 8th September 2021 has been complied with by the respective departments. Paragraph Monday, Mr. Ghosh. A paragraph, let the matter appear under the same heading on Monday, 7th August. 30 also same?
If
30 din. Yes, so same order.
The 54 is also same, but
ওটা 30 টা যেটা বললাম to ascertain whether the order passed on ডেটটা দিয়ে in 30 তে করুন সেম অর্ডার হবে। এটা 29 এ করেছেন তো 29 এ এটা থাকে যা আছে। আইটেম 30 তে হবে সেম অর্ডারটা হবে। শুধু ওই জায়গাটা একটু চেঞ্জ হবে যেখানে অর্ডার passed on ডেটটা আছে in WPA 111 of 2021. এটা আপনি এরকম করুন অর্ডার passed on খালি ডেটটা করে দিন 28 September 2021 has been complied with ওই ইনটা দাও order passed on 28 September 2021 has been complied same order with আগেরটা date
and 54
দেখি
54
No,
no
I'll
order,
just find it.
specific order has been passed, but involving similar issue. Let it be play.
no that is not
Similar
let
issue,
it be
madam.
called let it be called
Yes.
Hmm?
Let it play
No, no, no.
place with this matter.
there's an order for affidavits let it appear
These matters are all same matters. madam.
maybe but let it be called it's a different
Yes. As it was.
affidavits have been called
As it was.
31.
Lordship, is my matter. May I pray before your lordship to kindly go through page 22 of the.
respondents where is your affidavit
Mr. Shah is
Mr.
there.
Shah is appealing yes
Page 22. My lord, a writ petition was filed and this is the order of the writ petition. The relevant portion is on page 30. If your lordship kindly goes through the same.
who are the respondents here
Madrasa Education, Inspector of Schools, all we have served and academic service also.
Who is
given.
appearing for the madrasa education? I don't think
No
Mr.
one, no
Shah
one.
is appearing. Have you served the madrasa?
Yes, Lordship, we have served and I have.
Where is your service?
Lordship, this is a change of brief. I have the copy of the affidavit of service which has which was filed before.
Because it's not on record. The affidavit of service.
I have my copy.
They keep service achievement. Otherwise, this becomes a ground for appeal.
Lordship. This is my copy which was sent to me.
Yes.
It was
but,
change of brief. It was sent to me on February and these are the.
Where is the service on the secretary? It's not, I do not find the endorsement.
Lordship, may I?
Only the track reports. The postal receipt is not there. It appears to be.
Lordship says order dated 25 November 2021. No copy was served upon the state, but subsequently the copy
Right,
was served.
yes, right.
Yes, Lordship.
So it's over.
Over, Lordship. Now finally says page 30. That is the it was for enhancement of salary as per the present qualification. And the relevant portion is on page 31. Second para, the writ petition is disposed of directing the director schools of schools, Kujvihar, to grant scale of pay to the petitioner, taking into account his qualification on and from the last date of his examination, that is 23rd June 2021. This is relevant. The calculation to be made within a period of 8 weeks from the date of receipt of a copy of this order. The said respondent is directed to release all arrears payment within a period of 8 weeks thereafter and to release the current pay in accordance with his enhanced qualification as soon as the calculation is made.
Yes.
Now, Lordship kindly sees page 32. That is the next page, Lordship. This is the headmaster gives a letter to the DIO of schools where submission of arrear claims in respect of my client, Lordship.
Yes.
Now, Lordship sees page 39. 39.
Yes.
From the DIO of schools to the director of Madrasa Education.
Fund was not allotted.
No. Subsequently, Lordship, page 40. All concerned information, I was also given the copy of DIO schools with effect from such and such. Now, the most relevant part is, Lordship, page 34. Page 34 is the lawyer's notice, Lordship, dated 29th January 2021. If Lordship can kindly go through paragraphs number 2. That the order has been duly communicated in the month of October 2018. Pursuant to the order of the court, you have started to release the enhanced salary on and from January 2019. But you have not paid the arrear salary of the petitioner till date. Though the Honorable Court specifically directed you to release all arrears payment within a period of 8 weeks from the date of receipt of a copy of this order. That one year, 2 months already passed, but till date you have not paid the arrear salary to my client. And till date,
Not paid.
No, my lord.
So your claim is for area salary in this?
Area salary. I'm getting that enhanced rate from
The areas have not been
areas
paid.
are not paid. Is Lordship, if kindly sees the school is the page 32 is 16,43,399 as on 2019 February. The calculation was made.
Yes.
and Lordship. So as on 2019, 8 February 2019, this was my arrear. And now to 2023, I have not received a single pen.
The arrear has been calculated from 23rd June 2001 to.
That is from the order. In order page 32, Lordship sees page 31. 31 second para. On and from the last date of his examination, that is 23rd June 2021.
Yes. So till 2018, this amount has been calculated.
I'm getting the enhanced salary, but the area
Yes.
16 lakh and odd till 2019. It was calculated in 2019, Lordship. This is to 2023. I have not been paid a single according to that.
Let the state respond to this. You have not filed a contempt application.
No, Lordship, this is fresh application. This is change of brief, Lordship.
Yes, Mr. Shah, contempt would have made it faster.
Lordship. Mr. Alom filed this application and subsequently he could not come, so it transferred it to us. Direction as well.
Yes, Mr. Shah. Yes,
Lordship, in spite of
non-compliance of the
specific
court's order,
court order.
clear contempt. Yes? Very well, 2 p.m.
My lord.
Because nothing to adjudicate, you have to comply with the
That-
order.
that's-
Didi, 2 p.m.
Lordship.
Without 2 p.m. around.
Lord, I am for the petitioner led by Mr. Pipida. He is appearing online, my lord.
Well, I am appealing for the
Yes.
petition. My lord, this is relating to, my lord, the entire.
Respondents?
Already served, my lord. They were appearing.
Vikramaditya. Oh, to Vikram.
You are for the state? NHAI?
Supriya Singh Millard appears from the NHA.
Yes, yes.
Difficulty is not in the court. But I am holding the brief for her.
So shall I deal with the matter?
Yes. Now, my lord, this is relating to, my lord, the government of West Bengal granted lease in favor of the petitioner tea company, tea industries, Ranichera Tea Estate. Your lordship will find the indenture. It was from 3rd May 2013 for a period of, my lord, 30 years. So up to 2043. Now, my lord, the National Highway Authority, for the purpose of construction of the National Highway, acquired the same. Now, my lord, what happened after acquiring the same, they have granted or declared award in respect of the structure only. That your lordship will find from the writ application itself. That I'm drawing lordship attention at page. Page 37. Your lordship, I can turn to page 37. Because there is a decision for consideration of my representation where they have stated, my lord, by order dated 1st September 2022.
Page 37, yes?
Yes, my lord, will find the order dated 1st September 2022.
This is by the authority.
Yes, my lord, the special
Order
execution officer.
dated 1st September 2022, yes.
Yes, where your lordship will find, I am drawing only drawing your lordship attention to the specific portion of the order that is at the next page on scrutiny, last paragraph.
Yes.
On scrutiny, transfer the Ranichera Tea Estate Company
Structure
Limited
and tree damage,
structure and tree damages compensation following the order of issue of land and as per the order of the lessee shall be paid damages compensation for the loss of tree bushes structure, and according to the compensation was made, however, is a lessee and the compensation was directly paid to the applicant at first geo. Now, my lord, this is the whether the question is now, my lord, whether the lessee is entitled to get compensation on account of acquisition of the land or not.
That
this-
part has been turned down, Mr. Roy. Please see the last line, the penultimate line.
Yes, that is challenging the same, my lord. This application has been filed. It is not the, my lord, this is relating to, my lord, it is not an, this is in terms of the representation made by the petitioner, where your lordship will find this is an adjudication with the special land acquisition collector.
This is a 3G1 compensation.
No, this is 3G1, they have admitted that I am not entitled to get any compensation on account of
Under
land.
3G1, they have granted compensation for the structures.
Only structure. I am not agreed by the
And they have
structure.
stated that under 3G1, you are not entitled to land compensation.
No, they are saying that being a lessee, I am not entitled to, be as it may, my lord, I am not entitled to get any compensation on account of land. Now, my lord, the question is whether the lessee is entitled to get in compensation on account of land or not. Unless until the compensation is granted, I cannot make any arbitration because, my lord, if a lordship, any adjudication made, even agreed by an order, so but the entitlement is now in question. The similar question came up for constitution before this honorable court also, and with the honorable apex court, where it says, my lord, not only that the lessee is entitled to get compensation respect to both land and structure. First thing, my lord, I am drawing lordship attention. So for the judgment of our honorable high court, where this is reported in 2022 Supreme Court Online, Calcutta 2740. Justice Rao, as his lordship, dealing with the same thing, my lord, was pleased to opine.
Yes,
My lord, got it? The judgment
yes,
handed over to your lordship.
yes.
May I read out the relevant portion, my lord? Paragraph 2. On 71, a notification under 3.1 of the National Highways was published for acquiring a portion of the tea garden for the purpose of building, maintenance, management, and protection of national highway bearing such and such. The petitioners have submitted their objection to the said proposed acquisition on the suggestion members of the tea garden, my lord, skip over the same. The respondent number 4, being the competent authority, had rejected the objection made by the petitioner, and on such as a notification issued under subsection 1, read with section 3D2. After that, my lord, can you skip over? This is relating to, my lord, the issuance of notification. Now, my lord, if your lordship be kind enough to turn to the next page, Mr. Saptangshu Basu, paragraph 4, my lord, will find Mr. Saptangshu Basu, learned senior advocate representing the petitioner, submits that the impugned decision of the respondent number 4 is contrary to section 3G1 of the Act. Section 3A, 3J of the 1956 Act prescribe that the procedure for acquisition of land, in terms of section 3J, the Land Acquisition Act does not apply. He further submits that the section 3J of the Act of the 1956 Act for method of determination for the amount payable as compensation. Now, my lord, kindly consider the last. Next page, my lord, paragraph 7. Judgment.
Paragraphs are not numbered, which it starts with?
It starts with, my lord, per contra.
Yes.
Per contra, an advocate response submits that the terms of the order passed by the coordinate being such as the respondent number being the special language officer and competent authority have determined the compensation by the such and such for the respondent for the submits the competent authority has determined the compensation. It is not satisfied with the said determination as per 3G5 of the Act 1956. The petitioner had to approach the arbitrator. The counsel for the respondent submits that the competent authority had rightly determined the compensation on account of loss of tea bushes and the shade trees in terms of the memorandum dated such and such, as the petitioner cannot claim compensation with respect to the value of the land, as the petitioner is the lessee of the subject land. So this is the sum and substance, my lord, for the purpose of rejecting my claim. Now, if your lordship may kindly consider the relevant portion of the judgment, next page, your lordship will find that is paragraph. Paragraph 15, my lord, the relevant portion, my lord, I am relying upon. This court finds that the respondent before while passing the impugned order did such and such has neither considered the recommendation of the committee nor had considered the nature of the lease on the basis of which the petitioners are possession of the property and were running the tea garden. The respondent number 4 had passed the impugned order only on the basis of the memo dated such and such, and the memo relied on the respondent number 4 before this court. This court is of the view that the respondent 4 had passed the impugned order without considering the recommendation of the committee and the stand taken by the respondent number 2, 3, the lease deed, and thus the impugned order the petitioner faced for determination of the compensation pertaining to land.
What is this recommendation
therefore,
which is talked about?
This
A
recommendation is,
Yes.
recommendation, my lord, will find. Before that, your lordship will find that there is a honorable apex court that paragraph 16. No, sorry, back to corrected, my lord. Yes, 8, 9. Counsel for the respondent has relied upon the judgment. Is now, my lord, paragraph 9, my lord, that is page, my lord.
A recommendation has been talked about. What is this recommendation?
Just clarify, Millard, in that matter, I also had the opportunity to appear for the state.
Yes.
Millard, the government of Assam, in consultation with the tea industry association there, had prepared the minutes.
That is the recommendation.
Land valuation for tea estates should also be considered. But that had no binding effect on West Bengal
On
because the
this,
state
yes,
subject.
yes.
So however, that was referred by the honorable judge as a passing reference.
Only for that purpose. It is not the percentage effect, whether the land is there. Now, my lord, the same thing has came up for consideration before the Honorable Apex Court, where it is, my lord, the judgment reported in 1994, 5 Supreme Court cases, space 239,
Yes.
where your lordship will find the relevant portion is, my lord, at paragraph 5. It is a case admittedly. My lord got it, that portion.
Yes, yes.
The government being the owner of the land, the appellant held the demised land as lessee, with superstructure built thereon, and was in possession and enjoyment of the same on the date of acquisition. The contents of
Where are
the
you
award,
reading, Mr. Roy?
paragraph 5, my lord, that is at page 241 at the right hand corner. This is reported in 1994 5 Supreme Court cases, page 239, Inder Prasad versus Union of India.
No, no, this judgment is not there. This is Kiran Tandon versus Allahabad Development
No,
Authority.
no. Oh, my junior is supposed to hand it over to the prior to my lord. I'm moving the same, my lord.
Yes, he has done that. Yes. Yes.
Sorry, my lord, I beg to excuse, my
Yes,
lord.
yes.
In this case, my lord, paragraph 5, my lord, you will find that what is the issue before the Honorable Apex Court. Paragraph 5, my lord, got it?
Yes.
In this case, admittedly, the government being the owner of the land, the appellant held the demised land as lessee, with superstructure built thereon, and was in possession and enjoyment of the same on the date of acquisition. The contents of the award extracted herein before clearly indicate that the land acquisition contract could not determine could not determine the compensation payable towards the land leasehold interest held by the appellant. Being an owner, the government is not enjoined to acquire its own interest in the land or alone for the public purpose. When its land is granted on lease in favor of a lessee, its power to resume the land is subject to non-fulfillment of the terms and conditions of the lease by the lessee. So long as the lease acts and company complies with the covenants contained in the lease or by grant, the right to resumption in respect of the lease or grant would not arise. But when the land is required for public purpose, the government should get absolute title thereon, free from all encumbrances. Compensation becomes payable for the leasehold right or interest held by the lessee or grantee when the land is acquired. The point becomes clear from the following illustration. Take a case: the government granted lease of agricultural land on the annual payment of rent with the covenant that the government is entitled to resume the land when needed for public purpose or as when the government finds that the land is required for public purpose. In terms of the covenants, the government is entitled to exercise its option to determine the lease, though the lease has been complying with the condition of the payment of annual premium or rent or resume the land accordance with the terms of the grant. In that event, the need to take recourse to acquisition and make compensation does not arise. Take a case where the government granted the lease for an open land with permission to lessee to construct building for his quiet enjoyment with appropriate covenants, and the lessee permission constructed the building. By complying with the covenants, the lessee was in quiet enjoyment. The sales of property when required for public purpose, the government cannot unilaterally determine the lease and call upon the lessee to take a position. Therefore, the government is required to exercise its power eminent domain by invoking the provision under the Land Acquisition Act for granting such getting such land. The collectors have determined the compensation towards the leasehold interest held by the lessee, if accessible separately and determined by the compensation. The lessee being the owner of the superstructure and the government being the owner of the land. If compensation is determined for both the components, then the same has to be apportioned between them. So this is my.
This is a different issue now.
Yes, now whether I'm entitled to get compensation on account of land being the lessee of the plot. What I am shown to you, draw your lordship attention, the memorandum which based on which the state is saying that I am not entitled to get compensation on account of land. That is not, that also turned down by the honorable of this honorable court. Apart from the logic for the purpose of refusing my prayer, that was also considered. This is the same parameter with the Land Acquisition Act. The same point has been came for consideration before the honorable apex court, where this honorable apex court was of the opinion, no, that proportionally it should be divided amongst the lessee and the lessor. Here, my lord, my lease is up to 2040. I have making the I have made the structure in terms of the lease. They have admitted the structure is there, they have paid the amount. Now, whether I'm entitled to get any compensation on account of land or not, that your lordship will find that another same tune, my lord, 2019 volume 30 Supreme Court cases 382, where the same thing has been reiterated, where it says near about 80% of the compensation should be paid to the lessee who make construction and enjoy the property for the purpose of enjoyment. That your lordship will find the relevant portion.
Have you filed an application?
The representation was made. That application in that they have said that I am not entitled to get. In their report, my lord, if your lordship may kindly consider the report which was filed in terms of the previous order of this honorable court, where they have categorically said that in terms of that memo, which was referred by my lord Justice Rao in the earlier occasion, on basis of which I am not entitled to get any compensation on account of land. That your report, your lordship can consider the report once. My lord, got it? The report?
Yes, yes.
Your lordship will find only the award notice for structure and tree, part 2. My lord, at the top, next page, my lord. Not the first one, but the subsequent page.
Yes.
Reference payment of final compensation for land. My lord, got it? The reference in LKS numbers corresponding to LKS numbers at the top. My lord, next page at the top. Award note for structure and trees, part 2. After that, my lord, the payment of final compensation for land in arbitration acquisition case number 3 of 2017-18. My lord, probably I'm unable to point it out to your lordship.
I'll just find it. The second page. Award
Second
note for
page.
structure and trees. Yes.
Yes. After that, my lord, payment of final compensation for land in LKS number 3 of 2017-18. My lord, got it? After that, just reference.
Yes.
This award note relates. My lord, this is the, my lord, may I read out for your lordship. This award note relates to payment of final compensation for acquisition of 30.13 acres of land for the structures and trees in Moza, Ranichar Tea Garden, seat number such and such, Jalpaiguri, such and such, for 4-lane NHI under National Highway 1956. Notification 3A being such as such was published in the Government of India. The said notice was published. Notice being 3D being such and such, as estimated such and such. My lord, I am not disturbing your lordship.
The same thing is repeated.
Same thing has been repeated.
Yes,
The present
yes.
award, nothing has been. Why my? It is something. My lord, does not find any findings, adjudication, anything to that aspect. Then, my lord, if your lordship, my lord, keeping aside everything, my lord, can you consider National Highway Act once? 7, where, my lord, the person who is enjoying or displaced pursuant to the acquisition of the land in question, even a tenant or any, they are also entitled to get compensation in terms of at least 10%. I am only on the principle. The quantum I am not asking before a lordship. That is the subject matter. Whether my entitlement will be considered or not, that is the main thing. Your lordship can consider National Highway Act once, the section 7.
No, that is settled. Any occupant, yes.
Any occupier. So my occupation is not been challenged. Whether my right can be considered under 60 of the Easement Act, not, my lord, that is the subject matter, allowing me to make construction.
Let us hear the authority. Let us hear the authority.
Yes.
Yes.
Second round of litigation.
My lord, may I have your lordship leave?
Your voice is breaking, Mr. Roy. You're not audible. Yes,
Yes, my lord. Yes, my lord.
yes, you said something. Your voice was not audible.
Oh, no, my lord, may I have your lordship leave? And then
Yes,
my junior is there.
Yes.
He will, if it is necessary, my junior is also there in online. Grateful to your lordship.
yes.
Lordship, this is the second round of litigation where their
Please switch on the microphone because he'll not be able to hear you. Yes,
Wherein their representation was considered and a decision order was passed by special LO
yes.
Jalpaiguri, wherein it was held that they were entitled only to the
Structures.
structures and key bushes. They were already taking, rupees 4 crore 60 lakh.
That part is not in dispute at all.
That was done in the order itself. It has been clearly mentioned that it was done as per memo dated 28/7/93. We have also annexed the report with our report. Last page.
28th July, 93.
As per this memo, they were paid compensation only for the tree bushes which were they are entitled. Third paragraph from bottom. In regard apportionment of compensation between the lessor and the lessee, the lessee shall be paid damages compensation on account of loss of tree bushes and rent compensation for expired portion of the subsisting lease proportionate to the land. The lessor, that is the government, shall be paid the valuation of the land. And this and subsequently we have also annexed the notification which they are speaking of 10% compensation of the land value. That has also been annexed. That was subsequent notification dated 30th May 2018.
Yes, so they're entitled to 10% at least?
No, at least 10%, but as per this memo, it has been stated that it has no retrospective effect.
They are contradictory. Both are your documents, they're contradictory.
No, not contradictory. Their acquisition was done earlier to this notification. And at page 2 of that notification of 2018.
This is 2018. When was the acquisition done?
Page 2, clause 3.
When was the acquisition done?
In 2017. This notification of May and payment has already been made in March 2018. And it has been held that this provision shall only prospective effect in consonance with the provision of the prevailing act, be it either acquired or resumed.
Yes, what about the act itself? How do you ignore the act, the National Highways Act? Do you have the act? National Highways Act আছে কিনা? Do you have the National Highways Act 1956? আছে কি? এখানে ছিল? PG2 of that. Can there be any notification deholds this provision? Admittedly, he was in occupation, he's a lessee, admittedly.
that
So how can you ignore this provision? Any notification in contravention of this provision is bad in law.
they shall pay to an amount to the owner. It is owner, landowner. But our case is lesser and less.
Please read the entire.
That's where the right of user or any right in the nature of an easement on any land. It is not case of easement, the present case in an. in
Right
any
of
land.
user or any right in the nature of easement.
They shall pay an amount to the owner
After that, there's nothing. The sentence
and
stops
any
there.
other person whose right of enjoyment in the land has been affected.
So his right of enjoyment is affected,
Yes,
is the
accordingly,
lessee admittedly. So when his enjoyment right is affected, he is entitled to a compensation? Yes? Owner or any other person whose right of enjoyment in that land has been affected in any manner by reason of such acquisition. So you say that his right of enjoyment is not affected.
there comes the notification, the apportionment.
Forget about your notification. It is against the law. This is the act itself. The notification is bad in law.
Amount is to be determined.
Yes?
Total compensation, total land doesn't belongs to me. Here.
Apportionment, yes, you have.
apportionment,
You
but
can
he cannot
determine.
claim the entire
But
money.
you have, not necessary, but he'll get some money.
What is
You
there?
have said that he's not entitled at all.
That apportionment has been done by that notification of 2018. 10%. That is prior to. that
Have you
not-
made any apportionment at all? No, you have not.
As per earlier notification.
You have said that
He has suffered loss of.
I am not relying on 2018, nothing. I'm relying on the act itself, which says that any person whose right of user has been affected is entitled to compensation.
Then in that even.
3G2 is
Matter-
very
matter
clear.
when
You
is-
don't need a notification at all.
Matter may be sent to a special land division for in terms of the order passed in WBN 390.
In terms of 3G2, you have to make a calculation for apportionment.
Let the matter be sent to a special land division.
Entitlement, not an issue. He is entitled, you can apportion the amount. Yes, let it be sent for apportionment.
Reconsideration.
Yes, ma'am.
Propose this, similar to what Justice Krishna has held. In addition to that, Millard has rightly observed the provision and Millard the judgment.
He's
of the-
entitled.
Let him,
Yes.
let him determine. Let him determine.
He can
after-
only determine the proportion,
Yes.
not the entitlement.
Yes, Millard, before determination, the question of apportionment total. So let him determine whatever Millard, whatever law takes Millard,
Yes, but he cannot say that he is not entitled.
that's what we like that. I'm not going into that. Millard. Now let him reconsider this in light of the.
This recommendation of committee and all is not necessary at all because the act itself is very clear. Whether there is a recommendation or not, immaterial.
Let him reconsider.
My lord will only, my lord, one thing, my lord. Lordship will, my lord, only keep the ratio of the apportionment open. Otherwise, my lord, the authorities will be allowed to insist for 10%, my lord. In Justice Rao's judgment also, my lord, eventually when the matter went down, my lord, it was, my lord, 40% was held. Whereas, my lord, the Supreme Court has, my lord, in several matters, my lord, held that up to 80% it can be, my lord, the benefit can be, my lord, extended to.
You can place those judgments before the authority.
Yes, my lord, only keep that portion open, my lord.
When the apportionment is done, you will be heard.
My lord, grateful.
Heard learned counsels for the parties. It is not in dispute that your first line is wrong, Mr. Banerjee. The petitioner was a lessor.
My lord, I beg to be corrected. I beg to be corrected, my lord. My lord,
Paragraph 2, first line.
Yes, my lord.
It is not in dispute that the petitioner is a lessee in
Lessee.
respect of the plot in question, which was acquired by the respondents With a notification issued on. What is the date of your notification? It's not legible. A notification published on 19th January 2017, if I'm not wrong.
17.
Yes. On 19th, published on, issued on 19th January 2017. Stop. Though the petitioner was granted, was paid compensation, was granted, now was paid compensation for the structure and trees in the plots, comma. He was denied compensation for the leasehold land. Stop. Paragraph, it is submitted on behalf of the petitioner that the petitioner being a lessee in respect of the plots in question is entitled to compensation in terms of section 3G within bracket 2 of the National Highways Act, the National Highways Act 1956. Learned counsel for the petitioner, paragraph 40. Learned counsel for the petitioner has placed reliance on a judgment on an authority in Inder Parshad, P-A-R-S-H-A-D versus Union of India and others in nineteen 94, bracket 5 SCC 239. Wherein the Honorable Court has observed that observed as here under colon dash foreign line inverted comma open. Being an owner, the government is not enjoined to acquire its own interest in the land or land alone for public purpose. Stop. When its land is granted on lease in favor of a lessee, comma, the power to resume the land is subject to non-fulfillment of the terms and conditions of the lease by the lessee, stop. Dot, 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 বাকিটা বলছি না মাঝখানে একটা, হুম? But when the land is required for public purpose, comma, the government should get absolute title thereof, free from all encumbrances, stop. Compensation becomes payable for the leasehold right or interest held by the lessee or grantee, grantee, when the land is required. এখান থেকে বলবি, মিলে। A coordinate bench of this court. A coordinate bench of this court. Comma. By a judgment dated 14th September 2020, WPA 953 of 2019, comma, has 953, comma, in dealing with a similar matter, similar issue, has observed that the petitioner therein / lessee is entitled to a fresh determination for compensation pertaining to the acquired land of the lessee. Paragraph. In the case in hand, comma, the petitioner is admittedly the lessee in respect of the plots in question and has been denied compensation for the land by the authority. Stop. In view of the authorities referred to above, as well as the provision laid down under section 3G within bracket 2 of the Act of 1956, comma, this court is inclined to hold that the petitioner is entitled to compensation / proportionate share thereof in respect of the plots in question, of which he is the lessee. Stop. The concerned authority being the who should consider
The special land acquisition officer should
being
be.
the fourth respondent herein, comma, is directed to determine the compensation payable to the petitioner in respect of the land in question upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, and petitioner within 1 month, from the date of communication of this order, in the light of the observation made in the body of this order. Paragraph. The decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph. Necessary consequential steps be taken by the authority within a month of determination of the compensation. Disposed of.
My
1
lord,
month
only-
and another month.
My lord, the order has to be, my lord, in my humble submission has to be formally set aside, my lord, the 1st September order, my lord. Because they have
What is
already,
the- Where is the 1st September order?
Page 37, my lord, because they have already held that you are not entitled.
Actualize
That
Act
particular
of-
observation.
Only
is set
that part,
aside, yes,
only that
not the
part.
entire order,
আগে
regarding
করে, যেখানে,
non-entitlement regarding land.
তার আগে যাও। In view of যেখান থেকে বললাম, তার আগে in view of বলেছিল, প্যারাগ্রাফটা শুরু করেছি। কি দিয়ে শুরু করেছি প্যারাগ্রাফটা? তার আগে ওই প্যারাগ্রাফটা শুরু করেছি। পড়ো একবার পড়ো। এইখানটায় করো লেসি, in which is the lessee ওখানটা accordingly the order passed by the special land acquisition officer Jalpaiguri on 1st September 2022 insofar as the petitioner's claim for compensation of leasehold land has been turned down is set aside. তারপরে প্যারাগ্রাফ করে the concerned authority.
Grateful.
For Millard rises Millard, the one indulgence Millard, the
Yes.
5 and 6 item number Millard has
2 o'clock I
fixed at
said.
2 o'clock. Millard, can it be taken up at 3 o'clock instead?
Why?
Millard, 2 PM Millard, a contempt matter has been fixed before Justice Gangopadhyay. Millard, have to appear virtually. Millard, that
Very
this
good,
request,
very
I cannot make it virtually. That is the
Very
difficulty.
right. Where is the?
Millard, I
who's
will
appearing for the
intimate,
petitioner?
Mr. Chorodia is
Please
appearing.
intimate the
Yes,
petitioner.
I'll
Come at 3
definitely,
p.m.
yes,
Right.
3 p.m.
Okay.
Grateful. Millard.
এটার মধ্যে যাও। After 2 PM matter আছে 51.
2 PM. Yes. My lord, it was my matter. Non-compliance of course order.
Yes. Yes.
Thereafter, my lord, the DI of schools, secondary education, Kuch Bihar, in compliance of the honorable court's order, had extended the benefit of postgraduate scale of pay in favor of the petitioner. That was also granted.
The areas.
Yes, postgraduate scale of pay. Now-
Scale was granted.
Yes.
He's agreed with the areas.
My lord, my lord may kindly be pleased to direct the authority concerned. Here, the authority would be the director of Madrasa Education. That's the respondent number 2. That would solve the purpose of the petition. Within a specified period of time, because this ought to be.
Specific order is there.
Specific order is there.
More specific?
No, he's
Already
saying,
a-
at least, perhaps he's
There
saying
was
to
no-
direct
there was
to
no
disbursal
direction upon
fund.
the director of Madrasa Education as such. So I am praying before this honorable court to issue the, to at least direct, because that would, violation of this order would be tantamount to contempt of court.
Yes. Thank you.
The second respondent,
Yes, my lord,
the fund has to be provided by
by the second respondent.
by
It's
the
already,
second respondent.
it has already been written by the district inspector of schools to the director of Madrasa Education for release. of
Even the headmaster also communicated, lordship,
Remember,
but
AC গুলো চালাতে না।
why তুমি না? Headmaster জানিয়েছি তুমি এটা দেখো। Page 32 তে দেখো। 30
Third learned councils. No, the petitioner prays for grant of area salary for the period 23rd June 2001 to 31st March 2018, amounting to rupees 16,43,399 in terms of the order of this court dated 27th August 2018 in WP number 25608 within bracket W of 2010. Paragraph. The relevant portion of the order is set out.
Page 31, lordship.
Page 31, huh? The petition is disposed of today as soon as the calculation is made. Paragraph, learned counsel for the petitioner submits that though the scale of pay has been granted to the petitioner, comma, the aerial payments have not been made as yet. Paragraph. It is most unfortunate to note that the concerned, that despite a specific order of this court, comma, the concerned authority has not found it necessary to comply with the same till date.
But if I may, my lord, the direction was passed in the earlier petition on the district inspector of schools, secondary division. That was complied by the district inspector of schools. Now the direction is to be passed upon the directorate of madrasa education.
In the previous read, Director of Madrasa was also a party.
Also party, but
Also
the
party.
direction was specifically passed upon the district inspector of schools. That has already been complied with. My lord, page number 31, the first para.
The authority takes advantage of each line of the order.
I have to.
Paragraph, paragraph, it is pointed out by learned counsel for the respondents that the district inspector of schools within bracket SE bracket closed comma Kuch Bihar has assessed the amount of arrear salary payable to the petitioner No, this is assessed by the High Madrasa, the teacher in charge.
Lordship, and subsequently, the E also,
But
the DI also.
DISC granted the scale of pay, the higher scale of pay.
Lordship sees page 39. Basically of the assessment. The DI gave an representation to the Director of Madrasa Education.
It is good. Learned counsel for the respondents has pointed
Request to
out that-
release the. Supported reason.
that report that upon assessment of arrear salary payable to the petitioner, comma, the district inspector of schools within bracket SE bracket closed Kuch Bihar wrote to the director of Madrasa Education, comma, West Bengal on 5th February 2021
Release of fund.
for release of fund for the purpose. So learned counsel submits that such fund has not been released as yet.
Not been as of. that is
Such
the-
fund has not been released as yet. Paragraph in view of the above, the writ petition is disposed of, directing the second
Second
respondent
respondent.
My notice was also there, Lordship.
to release the required fund and take all necessary steps for disbursement of the same in favor of the petitioner in compliance with the order of this court passed on a year ago. বলেছি। হুম, হুম।
25608.
27th August 2018 in WP number such and such, 250608.
2010.
Within 1 month,
Got
within 1 month from the date of communication of this order.
My lord, interest. It was the order of 2018, Lordship. This is 23,
Interest at the rate of 8%.
Lordship.
Since payment of ABS, stop this, since payment of ABS salary has been withheld by the authority till date, comma, the authority is directed, the concerned authority, being the second respondent herein, is directed to pay interest to the petitioner on the said amount at the rate of 8% per annum. From June 2001, from 23rd June 2001 till actual payment of the amount.
Grateful, Lordship, gratefully obliged.
Disposed of it. Bas, ठीक है, हाँ. Next.
Yes, madam, I am for the petitioner. My only PR is to consider the representation.
You are
What-
stating wrong dates of the revised ROPA.
No, my lord, revised
in
ROPA in effect from, my lord, 14 February 2020.
You are not stating that in the application.
Well, 14
You are
February.
stating an earlier date. You are stating the date immediately after the date of superannuation.
That is
Again, a
single
wrong order
PP,
will be
single-
passed
uh,
in revised ROPA matters.
in corrected order, my lord, I have.
Yes,
But this petitioner is the owner of some
you are appearing?
plot of land, my lord. Now, my lord, what's happened, my lord, in the year 2020, it came to know that some portion of land which was illegally mutated some other person recorded,
Yes.
some other person. But thereafter, my lord, from 2021 to 2022, several representation was made before the block land and land reform.
Correction of record of rights.
No, no, but I therefore require some documents and for which authority kindly see 100 and
What is your prayer?
there is to provide
Correction of record
information,
of rights.
to provide the information.
Alternative
Page
remedies-
Prayer is primarily for
117.
correction of record of rights.
117 page.
Your prayer is primarily for correction of record of rights.
Another pair is to provide the information which short for
What information is sought for?
short for the
To consider the application under Right to Information Act, the
Yes.
court will not deal with such a prayer. You have an appellate provision if you do not get an answer.
thereafter I made an application before the district land reform officer. But
For
nothing.
what? So
For-
your prayer B cannot be considered by a writ court? Prayer A is under a specified act, the Land Reforms Act. Under the West
Section
Bengal
six-
Land
section
Reforms and Tenancy Tribunal, you have to approach the appropriate forum. So this court will not deal with your case.
Kindly consider my application.
Cannot be.
Kindly see page 119.
119.
This is notice of the
You have to approach the appropriate forum.
appeal forum is the LRTT.
Yes, you are aware.
LRTT is the for correction of record of rights.
That is your first prayer.
And second pair is I am
Second prayer is RTI, which all the more this court cannot decide.
I have made an appeal. Kindly see.
Not a
118 page 118. Is the this is the application, first application.
Certified copies, relevant papers in connection with the section 50 case.
certificate copies are fine.
Yes,
Certified copy in respect of preparation of new LR Khutian.
so that is
I
again
will-
specified act, sir.
Yes.
Will you withdraw to dismiss on this ground?
Then
This
my
court-
lord,
Yes,
Withdraw.
withdraw and approach the appropriate forum. I'll grant you liberty. Yes? Do you agree or have to dismiss? Specified act, this court cannot deal.
এটা হবে।
The matter pertains to the West Bengal Land Reforms Act 1955. Paragraph learned counsel for the petitioner seeks to withdraw the writ petition and approach the appropriate authority for redressal of the grievance of the petitioner. Paragraph in view of the above, comma, paragraph, the petition is dismissed for non-prosecution. Paragraph, liberty is granted to the petitioner to approach the appropriate forum for redressal of his grievance. Paragraph, there shall however be no order as to costs as in certified website.
Great.
Next,
And for the petitioner. Lordship, this matter. Revised PPO, Lordship, in earlier day, your Lordship.
I have heard it at length, yes.
Lordship, Lordship.
And there are earlier orders also of this court.
Lordship, for further consideration. Yes, your Lordship, free judgment, your Lordship, continental bench, your judgment. Lordships, I am page P1, your Lordship, that is appointment letter, page 31, your Lordship. Annexure P1. my appointment letter, your lordships.
You are appearing for the respondents.
Now, your lordship, P2, page 32 is the confirmation letter of service, your lordship. Now, your lordship, P3, that is my transfer order. I have first, your lordship, I am joined as a Sishu Mahal school. Subsequently, I have transferred from Umagati school, your lordship. That is page 33 to 35.
Yes.
Now, your lordship, P8, your lordship, that is page 55, that is letter of retirement, your lordship, on superannuation, intimate us. That is page 55, your lordships.
Yes.
Lordships, page P6, your lordship, page 40, your lordship, from, I am referring your lordship for showing I am, my date of joining your lordship, 31st July 1981, your lordship.
Yes.
Lordship, P17, your lordship, that is my last pay slip, your lordship.
Page 54.
P17. Lordship, page 93, your lordship. The last pay slip, your lordship.
Page 94.
93, your lordship.
Payslip for the last 6 months.
I have applied for the payslip, but they did not provide my, your lordship, payslip, your lordship. That is this letter, your lordship. My service book, your lordships, I have filed. Service book, your lordships, I have attached. In this case, your lordship. Service book, your lordships, P7, page 41 to 54, your lordships.
Yes.
Now, page 53, your lordship, showing your lordship my date of retirement, my date of joining, your lordships in the extra. Now, in this case, your lordship, I am attached some PPO, your lordship, from other teachers who are get their retrial benefit from the date of joining. Now, your lordships, I am first, your lordship, P9, your lordship, page 57, Shiuli Sarkar, your lordship. Shiuli Sarkar, your lordship, get the benefit.
They have relied on a letter issued by you where you had foregone the earlier part.
Lordship.
So now you say it was issued out of on compulsion or out of ignorance, whatever.
Lordship, in this case, your lordship, the impugned memo, first time, your lordship, I have earlier stated, your lordship, when I have joined your lordship in 1981, in the same memo, 12 teacher and 8 non-teaching staff were appointed. In 1988, your lordship, respondent number 5 confirmed the 4 teacher service and rest teacher service they have stated. The others are get the retail any benefit or lordship from 1988. Now, subsequently, one of the teacher approached before the Honorable High Court. Now, Honorable High Court allow their prior, your lordships. Then subsequently, respondent number 5 issue a memo, your lordship, which is annexed, your lordship, page 33 to 35. Sorry, your lordship. High Court's order, page 38 to 39, your lordship. 38 and 39. Lordship, I am reading last portion of 39 page, your lordship. However, in view of the decision of the Honorable Court, it is directed that such approval of the appointment of the petitioner be accorded with effect from 1981 without issuing on such undertaking being furnished. It is further directed that the petitioner be paid her arrear salaries with effect from 3rd August 1981 immediately.
You're at page 39.
Yes, Lordship.
This is an order of the Director of School Education.
Lordship.
You are saying High Court.
No, no, respondent number 5 issue the memo, your lordships, I have stated, on the
Yes.
basis of the High Court's order. Now, your lordships, in memo number P4, 36 and 37, your lordships.
Yes.
36 and 7, your lordships memo. Last portion of your lordships. 37, your lordship.
Yes.
As the matter was long pending to us, it was considered carefully, and after taking into account all the relevant factors, it seems that the payer is justified and rational. And as such, it has been decided that the service of the above noted teaching and non-teaching staff would be counted from their date of joining. An appropriate scale benefit would also be allowed notionally from that date. And monetary effect will be given retrospectively with 1st April 2003 as per their prayer. In 2000, issue is memo 2005. Now subsequently, your lordship, one SUVRA Shom, your lordship, file a writ petition. Before that, your lordship, impugned memo, your lordship, in 2016, respondent number 5 issue a memo, wherein it is stated that teachers and non-teaching staffs of the Sishu Mahal and others school get all the benefit from calculating 1988. Now, after the SUVRA Shom filed a writ petition challenging that memo, and she contained in this writ petition praying for gratuity and other retail benefit from the date of her joining, your lordships.
Will you please do one thing? It will be very helpful. You are referring to several dates and memos. Will you please prepare a list of dates and memo chronologically
Lordship.
so that it can be dealt with?
Yes, madam. Lordship.
Because there are other similarly circumstanced persons
Same
who have
matter,
been
your
granted this
lordship,
benefit.
Lordship.
Please prepare a short,
Memo number, your lordship, in SUVRA Shom matter, your lordship.
because you are referring to several memos which are not chronological. It should be year-wise.
Lordship.
It will be easier to adjudicate the matter.
Next is as a serial, your
The
lordship.
crux
but
is
I'm-
clear.
Lordship, I am
Crux is
referring in a different way, your lordship. But I am annexed in this writ petition is chronological, your lordship. P1, P2,
So please
P3.
prepare a list of
Lordship.
dates and the incident
Lordship.
chronologically so that we can derive at a conclusion.
Lordship.
Yes,
Lordship.
you'll come back tomorrow?
Lordship.
Yes,
Get no.
I'll just make it not today. Please assist the court with this
Lordship.
and give a copy to learned counsel so that he can also deal with it. Did not today quorum photo? Yes, petitioner.
I am for the petitioner in this matter.
Who is the
I am
petitioner?
for the petitioner in this.
Virtual.
Mala, it is a case of.
Mr. Ghosh for the.
Huh? Am I audible to your lordship?
Not clear.
Mala,
Yes, Mr. Bhattacharya.
Yes, yesterday also, Mala, I could not connect you.
Why don't you
Now
plan a visit to
I'm hearing-
Jalpaiguri?
Mala, can't.
It's not. I can see your lip movement only. Nice weather at Jalpaiguri. You can plan a visit. Very difficult with this network issue here. Anyone here representing here?
It's long trip.
Yesterday also same thing happened.
Mala, the petition. It is a very short petition. Kindly come to page 22 for once.
You are not heard. properly. One or two sentences we can hear, again it goes off.
Not hard watching at all. But I can hear your lordship full. I can fully hear your lordship.
Now I can hear you, but
I'm grateful to your lordship. Kindly come to page 22.
their respondents.
All have been served.
appearing. Who is appearing for the respondents? Mr. Ghosh.
Page 22 is the judgment of the Honorable Justice Hiranmaya Bhattacharya
Yes,
regarding the transfer
yes.
matter.
Yes, you be here. Let us see what the matter is about. Yes.
I have not appointed them.
My lord, very unfortunate case, my lord. A young lady, my lord,
The state,
had to travel.
the state advocate is not here, Mr. Bhattacharya.
Not the advocate appearing for school service commission, perhaps. Is it
My lord, it may not require your lord to dispose it of in
May not require the
state
respondent.
presence may not be required.
The school.
I
service
only want that. I only want that the order that has been referred to the Commissioner of Accreditation, let him take a decision on the issue. He has passed an order of transfer. That has been referred by the DI. And that reference has been made as far back on 7th of November 2022.
Shall I take
Till
it
today
at 3
that-
PM because Mr. Ghosh is coming at 3 PM, I think.
Has my
Mr.
lordship
Bhattacharya, will you wait for some time? I'll take it up at 3 PM.
What
Who is
was it?
this? Now, who is
Yes,
this?
after 3 o'clock I shall come.
3 PM, 3 PM.
3 PM. As your lordship please.
এখন 3 সময় Mr. Ghosh আসবেন, তখন একবারে।
Chalo.
I'm for the petitioner, my lord.
I beg to appear for the state lordship. Yes.
My lord, there is a substitution application, my lord. Because
Have
when
you
I-
served?
my
His
lord,
lordship.
during the pendency of the writ petition, the writ petitioner expired, my lord. And the wife has been
Let
filed-
this be allowed? Yes. Where is your application? When did you file it?
My lord, I have
Substitution
filed it on 15th of June.
15th of?
June.
Not today. I have to get the application. In the file. Do you have a copy?
Lord, I have already served to the office of the GP, my lord, after filing it.
Let the application, it is not there on file. Not today.
My lord. Keep the-
একটা order করুন তো। আচ্ছা, let me not
appear on the petitioner. I'm filing my affidavit of service.
Private respondents served,
All served, my lord.
several private respondents.
Yes, my lord.
Yes, what is the matter about?
My lord, this is the second round of litigation, my lord. My lord,
Yes.
the petitioner is a poor villager living in a small house with his family members, my lord. The family members, my lord, kindly takes up page 6,
Yes.
paragraph 3, my lord. The family
Yes.
members of the petitioner consist of school-going children, female members, and unmarried brother. My lord, the house of the petitioner is situated adjacent to a Pakka road, which runs parallel to the house of the petitioner. There is a Kacha road, which is of the irrigation department, used mainly by the petitioner and family members to access the main road, making it convenient for the petitioner and the family to go to the market, school, college, hospital, and to meet the daily necessities of life, my lord. The petitioner states that petitioner on such and such, the private respondent being such and
Unauthorized
such.
construction.
Yes, no, my lord. My lord, earlier, a writ petition has been filed, my lord, for, my lord, the private respondents are blocking the petitioner from using that Kacha road, my lord. My lord,
writ petition came up for hearing before Justice Saraf, my lord. The order is at page 18, my lord. Kindly takes up
Yes,
page
yes.
18. My lord, may I read paragraph 3, my lord? Council appearing on behalf of the state submits a particular block land is there, belongs to the irrigation department, and same can be removed immediately in light of the, let the blockage be removed by the state within a period of, my lord, immediately I communicated the copy of the order to the respondent authorities, my lord. Communication is that next page, my lord. My lord, after communication, the blockage has been removed by the state respondent. My lord, subsequently, after removal of the blockage, again the private respondents are creating, my lord, obstructions for passage of the petitioner from using the path, my lord. My lord, on my lord, May, sometimes in the middle of May 2023, my lord. My lord, the private respondents, they attacked your petitioner, my lord. They attacked you with, my lord, sharp weapons, knives, my lord. They till date, they are constantly threatening your petitioner, my lord, from and restricting the petitioner from using the Kacha road, my lord, which belongs to the State Department, my lord. My lord, in that, I made a complaint before the concerned police station, my lord. FIR has been lodged at page 22, my lord. And my lord, in that event, my lord, my brother was seriously injured, my lord. I have annexed the injury report also at page 25, my lord. Annexure P4, my lord. My lord, till date, my lord, the private respondents are coming to the house of the petitioner and constantly threatening them, my lord. And they are threatening not
If
to.
they are threatening you, that is a criminal case. What
Yes,
is
my
your
lord.
prayer in the writ petition?
My lord, my I have made a composite prayer. In the my first prayer is, my lord, kindly takes up the prayer. The concerned authorities that the village road can be reopened for ingress and outgress of the petitioner, my lord, and also tender prayer be, my lord, written in the nature of commanding respondent to tender necessary assistance to your petitioner for protection of life and property. My lord, I have brought with me few photographs, my lord. Kindly see the road. Condition of the road, my lord, how they have blocked it. My lord, kindly take a look, my lord. My lord, my lord, and due to the said blockage, my lord, there is the water gets clogged down, my lord. The constantly the snakes and reptiles during the rainy season comes to the house of the petitioner.
Photographs are neither here nor there. Where is your house? Where is the road? How can you make out from this?
My lord,
photograph?
this is all the photographs I have, my
So
lord.
it doesn't make any.
My lord, kindly considers my prayer, my lord. This is the second round of litigation. Earlier order has been
Yes,
passed by
yes.
Justice Saraf.
Yes.
My lord,
My lord,
despite of being an order, my lord, the parents, they are threatening, my lord.
if I may.
Huh.
What has happened in this case, there was a previous round of litigation wherein the honorable court passed a specific direction to clear the path. That has already been done. Subsequent thereto, petitioner lodged complaint that has already been registered. Case has been initiated. Charge sheet has been done. So the
A
responsibility. of the-
further blockage.
But my lord, there is no further blockage. This was cleared by the respondent authority.
He says after that there has been a
My lord,
blockage.
pursuant to the complaint that has been registered by the petitioner. Pursuant to the complaint, FIR has already been lodged. That investigation is currently there. Two separate
Complaint
FIRs.
FIR is one aspect. The other aspect is blockage. That's.
Well, the land belongs to the irrigation department and it is not situated adjacent to the house of the petitioner. Even. It is.
But in the earlier matter, you said that it was.
Well, it is a path which is used by certain some persons of the locality, including the petitioner. It's not that the petitioner only uses that path. It's the land of the irrigation department.
There cannot be any encroachment on the said land.
But there has been no encroachment. Encroachment has already been cleared. Now the petitioner is alleging that he is unable to use the said path because the other side is threatening him and all that. That has already been registered
That
as
is
an
a
FIR.
criminal proceeding.
That has already been registered as an FIR.
My lord, but where will I go, my lord? My lord, I am unable to use the road, my lord. I am unable to use the said road. My lord, I am kept in a cage, my lord.
Well, prima facie, he doesn't
Lord,
have a
you
right. He
have
doesn't have
lodged
a
a
right over the said
complaint.
road also.
Yes, my lord.
You,
My lord, I have lodged, my
and
lord.
the writ court
Pursuant to
cannot deal
complaint,
with
no
that.
steps were taken, my lord. Only FIR has lodged, charge sheet has been filed. My lord, till date they are threatening,
So
my lord.
can the writ court deal with the criminal complaint?
My lord, but this is the land belongs to the State Department. Later, the State Department takes initiative to clear the road, my lord.
My lord, there is no encroachment. My lord can record my submissions. As of now, there is no encroachment upon the land concern.
Very well. Affidavit of service. None, paragraph, none appears for the private respondents despite service. Paragraph. It is contended on behalf of the petitioner that pursuant that the petitioner alleged blockage of a pathway leading to his house by the private respondents. Stop. Pursuant to an order passed by a coordinate bench of this court on 8th December 2022 in WPA 2119 of 2022, comma, 2022, comma, Nadir, directing the state authorities to remove the said blockage within 7 days from the date of order, comma, the blockage was admittedly removed. Stop. The petitioner submits that the private respondents have again blocked the egress and ingress of the petitioner, and are restraining the petitioner from using the pathway in question. Paragraph. Learned counsel for the state respondents submits, comma, on instructions, comma, that after removal of the encroachment in compliance with the earlier order of this court, comma, no further encroachment has been made by the private respondents, and the pathway in question is free from any encroachment as on this date. As on this date. Stop. Learned counsel further submits that pursuant to a complaint lodged by the petitioner, a criminal proceeding has been initiated against the private respondents, and charge sheet has been submitted, therein. Paragraph. In the present application, comma, the petitioner has prayed for removal of encroachment from the passage, from the pathway leading to his house, pathway leading to his house, and necessary assistance for protection of life and property. Paragraph. In view of the submission made on behalf of the state respondents, comma, nothing further remains to be adjudicated in the writ petition, and the same is accordingly disposed of.
Lord, may I pray for one more thing?
WPA, yes,
May I pray for one? Let the SP be directed to keep a strict vigil on the land, my lord. My lord, they are constantly threatening me, my lord. I'm unable to get out
however,
of my
paragraph
house.
Kurun, however, the state respondents are directed to ensure that no encroachment is made upon any land belonging to the state authorities with regard to the writ petition. Why the land involved in the writ petition? Encroachment was removed. He says there is encroachment, you say there is no encroachment.
If there was encroachment, you would not have been.
So let there be no encroachment in this land.
That is going to continue.
That is the yes. Can there be an encroachment unless you lease out the land? I have recorded your submission.
I'm deeply obliged, my lord.
Which after line have disposed of. Next.
May it please this honorable court. My lord, this matter appeared yesterday
day before yesterday, where
Yes.
the time was. No, courtroom number 1, his matter has not yet started. I have seen it and checked it myself. 37 is going on. His matter has not yet started. I'm opposing the prayer, my lord. I'm opposing the prayer. I have seen it myself. My lord, I have seen it by myself. Item number 37 is going on in court number 1, and he is not in item number 37. My lord, let me. Yes, but this is our answering respondent is CGST. And last time the state respondents were present, CGST took time. They were not ready with the matter.
Who is appearing for 1, 2, and 5?
Mr.
are
Bonik
ready.
is appearing. Mr. Bonik is appearing.
Yes,
Yes.
you are
So
ready.
No, ma'am, actually, he's in court number 1.
Who is
no,
in
he
court
is not
number
in
one?
court number 1.
Who is in court number 1?
Mr. Bond.
But his matter is not being taken up by court number 1. Item number 37 is running. He's sitting there waiting for his
So do
matter,
you
my lord.
expect that this court to call for affidavits now?
No, my lord.
As to whether he is in court number 1 or not on that
My lord, I
point.
myself saw it. I
This is
checked
very
it.
embarrassing for
very,
you
very
as well, I
embarrassing
think,
for
for the
me as
court
well,
also.
lordship. It's the type of submission I never wanted to make. My lord, let me open the matter. Their juniors are there.
3 matters are waiting for 3 PM because Mr. Ghosh has
Yes.
to come and address. Here also Mr. Ghosh, no.
But Mr. Ghosh is not
For this
addressing
thing.
here. Mr. Ghosh is not addressing here. Mr. Bonik will be addressing.
Passover not possible in the second half, it's difficult.
My lord will kindly say, I'll just start the matter.
Not today.
My lord kindly sees this
Come back
matter
tomorrow.
was taken up day before yesterday, and this was taken up. Probably my learned friend is here.
My lord, kindly allow me 10 minutes time. My matter has already been called in the division.
It's not
So
yet
I'll
got, sir.
make it not today in that case. Today, 10 minutes will not be possible.
My lord, kindly see the only predicament is this. The only predicament is this, my lord. Any day they will attach my account. Any day now, because they have already served me with emails threatening me to either produce the stay order or to get the order set aside. They will any day now get my account attached. The only short point here is this, my lord. Due to their misgivings, I could not file a proper appeal. They had not given me the appellate order or the notice of demand. They had not given it.
I'll just make it not today, come back
My
tomorrow.
lord, may I
Please be
may I
ready
just
tomorrow.
my
Please
lord,
be
may I
ready
may I
tomorrow.
just pray one thing,
Not today.
that let it be taken up if the time permits. I will wait, because this is what happened day before yesterday as well.
Come back tomorrow, let us see.
My lord, kindly,
It may
kindly,
so happen that you also may need an accommodation someday, isn't it? So please do not object to
my
accommodations.
lord, I never do object to accommodations, but this is the only
And it's
thing.
only
This
for
is-
a day. Yes. Yes. What about the respondents? Please switch on your microphone.
My lords, this case relates to assessment year 2006-7. Scrutiny assessment was conducted and an order was passed in the year 2008. Additions were made in the returned income on 3 accounts, my lords. First was purchase of material, second was purchase of labor, and third was long-term capital gains on sale of land. Thereafter, my lords, we filed the first appeal. CIT appeal confirmed. We filed the second appeal, ITAT allowed our appeal, set aside the order, directed the learned AO to recalculate afresh 2 items. Purchase of material and labor, long-term capital gains were set aside. Thereafter, my
The
lords.
first 2 were confirmed.
Yes. No. First 2 was sent back. It was set aside.
For fresh assessment.
Yes. For
And
fresh
the long-term capital gain was
set aside.
affirmed.
That was the major addition in my case. Thereafter, my lords.
So all 3 were set aside.
Yes, I have the order with me. It was directed that consider afresh and check, verify if it is genuine. Thereafter, my lords, the matter came back to the learned AO. in 2017. In 2017 December, the learned AO giving effect to the ITAT order confirmed the two additions, which was asked for reconsideration. They confirmed, they raised the demand. In this order, my lords, the interest calculation, interest under section 234B, they took 11 years as they charged interest for 11 years. Up to the date of order, they charged interest. I filed a rectification application after that. I relied on a ITAT Delhi decision, which effectively relied on a Supreme Court decision, which stated how to calculate interest. Now that appeal, my lords, was allowed in 2020. This is that order, my lords, is at page number. First, I will show you, my lords, the order passed at page number 30, my lords. This was the order, first order, the appeal effect, when the assessing officer gave the appeal effect. At page number 30 is the order. Page number 32 is the calculation. Thereafter, I filed a appeal. Thereafter, I filed a rectification application, which was rejected, against which I filed an appeal, which was subsequently allowed in the year 2020, which is annexed at page number 42 of my writ petition, my lords. Operative part of the order is at page number 46. I have considered the submission. Last part, my lords.
Give me a minute, please. (46).
Yes.
Yes.
46, 47. Now this appeal was allowed, and AO was asked to take note of this decision and recalculate the interest afresh. Thereafter, my lords, I filed an application to the assessing officer, next page at page number 48, to give the appeal effect. It took me, my lords, 3 years to obtain that assessment order. Finally, that order was given to me, which is at page number 56, my lords. 59 is the impugned order, which I am challenging in this writ petition. My lords, what they did was they removed that interest.
This is the fresh calculation, the
Yes,
revised calculation.
yes. After multiple rounds. So what they did was, my lords, they removed that interest under section 234B and they charged the new interest. That is under section 222. You will find it, my lords, in the lower part. Interest under section 222 at the rate of 1% per month for 121 months on 3,85,000. Totaling rupees 4,65,000. I was supposed to get a refund. They created a demand thereafter. Now, my lords, I am challenging this order. I'd like to show you the first, the provision, my lords. Dada. Please take, my lord, section 220. Or the interest has been charged under section 222. So I like to show you 220, my lords, 222. This is a recovery proceedings, my lords. Section 220.
Yes.
When tax is payable and when assessee is deemed in default. Now, my lords, what happens is that once an assessment order is done, they issue a notice of demand. In that notice of demand, they specify a date, which is normally 30 days. Now, after that 30 days period is over, this interest starts accumulating, my lords. This is stated in 222, my lords. If the amount specified in any notice of demand under section 156 is not paid within the period limited, under section 1, the assessee shall be liable to pay a simple interest at 1% every month or part of a month comprised in the period commencing from the date immediately following the end of the period mentioned in subsection 1 and ending with the date on which the amount is paid.
Yes.
My lords, if you take page number 60 of my writ petition, page number 60 is the notice of demand, which was served to me after that ITAT order they had given effect. They had
Page
raised the
numbers?
demand of page
Page?
number 60, my lords. They had raised the demand of 7,16,000. Date you will find, my lords, in the low bottom part, 28th December 2017 is the date. Amount is in the first paragraph, 7,16,000. Next page, my lord, is the challan payment, which was paid in after 5 days, my lords. On 2nd, 1st, 2018, challan amount
This
is
is the initial demand.
no, my lords. This is when the matter after set aside of the after the ITAT allowed my appeal, it was sent back to the AO.
For fresh calculation.
Yes, fresh calculation, they raised this demand. This demand was cleared by me after 5 days, my lords. 61, 62 is my challan details. 62, you will find the amount, my lords. 61 is the challan detail. 62 amount you will find 7,16,000. So there was no demand.
Yes.
Now, my lords, I'll again take you to page number 59, my lords. Kindly, the impugned order.
Yes.
Kindly see the heading, my lords. It says that order under section 251 of the Income Tax Act. Now, 251 deals with powers of appellate assessing appellate authority. I'm showing this because I'm indicating the casualness with which how the order has been passed, my lords. Now, my first point is that, my lords, this entire order is completely illegal. They had no jurisdiction to raise demand under section 220 because I had cleared my demand. Now, this demand can only accrue once I have not paid my demand. Mere demand notice will not suffice. And they have charged me interest for 121 months, my lords. From January 2008 to 2018.
This demand was made on 28th December,
My lords, which demand?
page 60.
This is, my lords, 2017. After the ITAT order.
Yes.
This demand was raised by the AO. This I had cleared. Thereafter, I filed a rectification application. I paid my demand. I filed a rectification application that was rejected. I filed an appeal. Appeal was allowed. Sent back to the AO. AO again calculated demand at page number 59. He gave effect to the appeal order, removed that 234B demand interest, raised another interest, my lords. Completely illegal, without jurisdiction, my lords.
Where is the appeal order?
Appeal order is at, my lords,
47?
my lords, 42 to 47. ITAT order also, my lords, I have.
There was a direction for recalculation of interest under 234B.
Yes, my lords. And what they did, they removed that interest. They allowed that, they gave that effect, but they raised another interest under section 222, which was completely illegal and without any jurisdiction.
What does 234B say?
234B, my lords, it says advance tax, interest, shortfall of advance tax, my lords. This interest is interest for default in payment of advance tax.
So was there any default on your part in payment of advance tax?
My lord, that matter has been settled. AO also removed that demand. But what they did was they raised another demand that was under
So
interest.
you're on 220B now.
Yes, that I am challenging, my lords.
Let us hear the authority. Yes.
But any amount otherwise than why you have advance tax is specified in favor in notice of command under section 156 shall be paid within 30 days of the service of the notice at the place to the person mentioned in the notice, provided that where the assessing officer has any reason to believe that it is destinated to revenue if the full period of 30 days approachment is allowed, he may, in the previous approval of the joint commissioner, direct that the sum specified in the notice of demand shall be paid within such period, being a period less than the period of 30 days appropriate, as may be specified by him in the notice of demand. Now, 1A, your lordship, this is 2040 after amendment. Where any notice of demand has been served upon an assessee and any appeal or other proceeding, as the case may be, is filed or initiated in respect of the amount specified in such notice of demand, then such demand shall be deemed to be valid in the disposal of the appeal by the last appellate authority or disposal of the proceeding. Now, your lordship, 222 says, if the amount specified in the notice of the demand under section 156 is not paid within the period limited under subsection 1, the assessee shall be liable to pay simple interest at 1% for every month or part of a month complied to the period commencing from the day immediately following the end of the period mentioned in subsection 1.
Yes.
Yes. Now you see. Page 59. Let's see, I'm comparing.
So when was the demand made?
Lordship. Lordship, the assessment order was assessment year, your lordship, 2006 and 2007. Now, your lordship, 2006 and 7 is the assessment year, your lordship. Then after the financial year within 30 days, that assessing your lordship duty to pay the amount, your lordship. If any amount, your lordship.
220B says
Lordship.
within 30 days or the date specified
Lordship.
upon demand.
Lordship.
So when was the demand made?
When my lordship 20 assessment your lordship 2006 and 7. Now subsequently he will to file an appeal. Or the appeal rejected 154. Then after appellate tribunal, your lord.
That part is
Now-
over, isn't
Now
it?
lordship till date, your lord. The assessment is valid. Assessment is valid. Now subsequently authority says calculating the interest only to 34B. Now the rest amount, your lordship, the assessment, which I told your lordship, the assessment 4 lakhs, net amount payable, your lordship, 4 lakhs 10,485. That is computation of tax follows, your lordship, page 32 and page 59, your lordship. Total assessment 284,687 is the tax, which is undisputed, your lordship. Now subsequently.
Page 32 is the tax?
Computation of taxes.
This
Page
is,
32. It's 7 lakh and odd.
Yes.
I clarify, your lordship.
this tax, my lords, is demand notice is at page number 60.
Interest under section 234B is 4,25,683, which is disputed. Which is disputed, your lordship. Tax, your lordship, 2,84,687. Up to that undisputed. Now subsequently dispute
234B, yes.
Authority says, your lordship, tribunal says, recalculate that interest. Now subsequently assessment, your lordship, up to 2,84,687 is same.
Yes.
59. 234B, your lordship, after calculating it was 93,947.
They agreed to my calculation.
Lordship. Whatever.
Where do you get
Then
it?
your lordship.
My lords,
this
at page
amount-
number 59, he's saying.
59. Now let's see total amount due balance payable 3,85,103, your lordship.
Yes, till this, there is no dispute.
Yes,
Lordship,
no dispute,
lordship,
no dispute.
lordship. Now, if this amount, when payable, your lordship? Interest calculated, your lordship, upon 3,85,103.
The proceeding was pending.
Lordship, I have the judgment, your lordship, if the proceeding says, section 1A, your lordship, 220 says, till disposal of the
Last
proceeding,
appellate.
your lordship, it is a continuous valid demand. Now, what I cited, your lordship, section 1 judgment, your lordship, this is 220.
So demand is valid.
Lordship,
Can you charge an interest for non-payment within 30 days or whatever?
Yes.
Because the proceeding is
cannot.
continuing.
the proceeding is continuing, but income tax says, your lordship, a assessee should be paid the amount after the financial year, your lordship, will be 30 years.
My lord, I'll place one circular of their board
Yes.
on the same issue, my lord. Here, 1982.
2014, your lordship said, 14 or 1A says, it is a continuous, but till disposal of the appeal, it is a valid demand.
So
Not
my
only
appeal
for
was
the
disposed,
same
my
point.
lord. My appeal was set aside. No, what he's saying, my lords, what he's submitting is that the original demand, which was set aside by the ITAT, that on that he's saying that interest should be chargeable.
Several factual disputes, please come back on affidavits.
My lords,
Because
kindly,
you need to come back with several documents.
my lords. My lords, kindly, I am pressing for interim, my lords. Kindly stay off the month.
What interim order can
Stay,
be
my
passed in
lords.
this matter?
Stay, my lords. You can stay the demand, my lord. Completely illegal. No, my lords,
This is
kindly see
under
the.
challenge. There cannot be any coercive action for this, so there is no chance of a stay order.
There may, my lords,
What is the coercive action that they can do?
they can freeze my account if I don't pay the sum. But I have paid the sum. It's fine, my lords. I have already
Come
paid
back
the.
on affidavits because you're relying on several documents.
Sure,
It's
sure.
a factual dispute. Upon consideration of submission made on behalf of the parties, this court is of the view that the matter needs to be heard on affidavits. Paragraph affidavit in opposition we file within 2 weeks. Opposition within 3 weeks from date. Stop affidavit in reply, if any, be filed within a week thereafter. Paragraph, the matter be placed before the next available circuit bench.
Grateful, man.
You can take back this document. You
My
have
lord.
to file it again.
Fine.
PPM will do. Yes, 3 PM matters.
My lord.
You are the petitioner?
My lord.
Yes.
My lord, in a very concise manner, my lord, if I may submit, my lord, without wasting the much of the time of your lordship, my lord.
Who is appearing for the additional commissioner of revenue, commercial tax? You are appearing for all of them? Right. Yes.
My lord. Lord, I am a reseller of a sweetmeat and certain snacks, my lord, at Siliguri, my lord. I have 5 places, my lord, from where I operate. Now, my lord, they visited and investigation was carried on. Subsequently, the notices followed, my lord. I gave a reply, and at the end, my lord, the so-cause notice was given. Against the so-cause notice, I replied. In the very last line, I said that in case you need, you differ with this, kindly provide me an opportunity of personal hearing. My lord, 75
What is the allegation against you?
But they say that certain taxes against the sale has not been paid. My lord. Where although I am covered by certain notification, I paid tax, but as a lesser amount. I am covered by a notification. Now, my lord, I said in page number, my lord, if lordship comes down to page number 105, my lord.
Yes.
My lord. My lord, here, my lord, if lordship comes down to the 11th line, my lord. We therefore request your good self to kindly acknowledge the above response along with the relevant annexures and drop any further proceeding in this regard. We also request your good self to convey to us any further requirement, as we are always ready to cooperate with the department with regards to the proceeding in this case and be a regular tax compliant. We crave leaves to alter this. In case your good self feels otherwise, we humbly request you to kindly allow us an opportunity of being heard in person, but before passing any speaking order in this regard. My lord, takes up, my lord, section 74(5), my lord. Thereafter, I'll be placing certain judgments of, my lord, Gujarat High Court as well as, my lord, Allahabad High Court on this very point.
Section?
But 74(5), my lord. My lord, on the
74(5).
74(5), my lord.
Yes.
Lordship, you've gone, my lord. But here it says that an opportunity of being heard is to be given when provided.
74(5) says otherwise.
My lord, 74(5) says, no, it's, my lord, 75(4), my lord. No,
Yes.
reverse. Extremely sorry, my lord.
Yes. Right, yes.
My lord, any opportunity of hearing shall be granted where a request is received in writing from the person chargeable with tax or penalty, or where any adverse order is contemplated against that person, my lord. My lord, here, my lord, I'll be placing before your lordship, my lord, two judgments, my lord. But this is the division bench judgment of Honorable Gujarat High Court, my lord. My lord, paragraph number 2. My lord, what was the moot point, my lord, before the court, my lord? This is a
Yes.
Well, this is a petition seeking direction to set aside an ex parte order passed in from GST DRC 7, dated this, passed by the respondent number 2 without following the principle of natural justice. The fact relating to the present case are the petitioner Mrs. Eagles, this. So-called notice was issued. I am on the
Personal hearing was not granted.
not
That is
granted.
your-
My lord, 2.2, my lord. On the
Yes,
ground that the
yes.
mandatory opportunity of personal hearing was not granted as required under 75(4) of the CGST Act, the petitioner is before this court seeking to challenge this order. My lord, thereafter, my lord, lordship turns out to the next page, my lord. My paragraph number 4, my lord.
Yes.
This is not disputed that the personal hearing has not been granted in the instant case. This is an ex parte order of DRC 7, my lord, passed by making the huge amount. This. The decision of the court in the case of Graziano Transmission India Private Limited versus State of Gujarat, my lord, and other decision will need to come to the rescue of the petitioner, which insists on providing an opportunity of hearing, personal hearing, when an adverse decision is contemplated, even without any request for personal hearing on the part of the party concerned. My lord, here, my lord, without any request also, if any adverse order is contemplated to be passed, my lord, a personal hearing is to
That
be
is
given.
natural justice.
That is settled, my lord. My lord, I need not show this, my lord. I was basically, I did not bring this judgment, my lord, as because lordship passed this matter, my lord. I went and got this judgment. Otherwise, I do not rely upon judgments, my lord, much of this. My lord, and thereafter, my lord, 5.54, my lord.
Yes.
The provision of the law, my lord, 75(4) is provided, my lord, 5.1, my lord, an opportunity of hearing, my lord.
Yes. Yes.
Thereafter, my lord, the next page, paragraph number 6. My lord, the order, my lord, judgment, my lord. Accordingly, the petition is allowed quashing setting aside the impugned order of assessment with all consequential proceeding. Rule is made absolute for to the aforesaid extent. The respondent is at liberty to initiate the proceeding from the stage where it has been left by affording reasonable opportunity of being heard to the petitioner on intimating him even physically. My lord, this is, and my lord, I need not go into the next judgment, my lord.
Where is
It
the
is-
impugned order?
My lord, page number, well, it follows next, my lord. 107, my lord, page number 106. This is the final order, my lord.
Yes. So you're asking for an opportunity of being heard.
Yes. But setting aside only the order is in page number 106, setting aside and providing me a fresh opportunity of being heard, my lord. Personally, my lord.
Yes, Mr. Ghosh.
What has been submitted before your lordship, my lord, is contrary, my lord, on the face of it, contrary to records, because the initial investigation on the basis of which the case was started, that was on 18th of May 2022. Now, my lord, subsequently, the final order, if my lord finds at page 106, it has been passed on 18th of May 2023. In between, my lord, the authorized representative of the RTP was heard. Personal hearing was heard, my lord, on eight dates. I have the dates with me. My lord, the email conversations through email, my lord, whatever he has submitted, his submissions that were duly considered. There were 5 exchange of communications. And my lord, each of those 5 communications were addressed by the authorities by 6 replies. I have the dates and the documents with me. A final adjudicating authority has now passed an order. His remedy lies in appeal. There is an appellate authority. So, my lord, I don't know, my lord, what case has been
How do you
demonstrated.
show that he was heard before the order was passed?
My lord, I have the dates. I have the dates with me. On each of those dates, my lord, his representative was present. He was heard. He was given a hearing.
My lord, it is a fact, my lord.
The
It is a fact, admittedly, my lord, but my lord, one judgment, my lord, on this very point, whatever he states, my lord. Bharat Mit, my lord, Allahabad High Court, my lord. My lord, page number 2, my lord, paragraph number 4, my lord. I'll take some time, my lord, because he has raised this question. my
So
lord.
a personal hearing was given to you.
No, my lord, my lord, my lord. My lord, a notice, what is the GST follows, my lord. A DRC notice, pre-so-called notice has to be issued in DRC 01A. It was issued, I gave a reply. Against which a so-called notice was issued, I gave a reply stating that if you're not satisfied, give me a personal hearing, man.
So after that, no hearing was given.
Yes,
A
yes, it
order
was given.
passed in DRC 07 without providing me any personal.
No, no. no,
This
no,
is my case. my lord.
Learned counsel says that after your show cause,
My lord,
asking for years.
my lord, let it be placed. My lord,
How
this-
do you substantiate that he
Yes.
was heard?
No, my lord, kindly. my lord,
There
kindly
should be
see.
some order sheet saying that he was heard.
My lord, kindly see.
my lord, the order sheet in page number 606.
My lord, the order sheet is the final order of the adjudicating authority. Now, my lord, on what dates he was heard, whether there was any personal opportunity of hearing or not, my lord, he admits he was heard. And my
No.
lord,
He
prior,
admits he was heard earlier,
Earlier.
not after the
Yes,
show cause notice.
my lord, kindly see, my lord, the show cause notice in form DRC 1A was issued on 1st February 2023. There cannot be any dispute to this.
1st February 23.
23, admitted. The
Yes.
hearing dates are 10th February, 13th February, 21st February, and 27th February.
That
4
is your
hearings.
submission. How do you substantiate your submission? You have to show the court that on these
Look, they're not
dates,
disputing to it.
they are disputing.
They are saying that prior to issuing of the final order, that is, my lord, on 18th of May 2023, no hearing was granted. That's what they're saying. But I am saying
No.
in
They
between
are
the show
saying
cause,
After response to the show cause notice, no hearing was granted.
so allow me my lord, a day's time to disclose the records on what dates they were heard.
The response is on 18th April 2023.
My lord.
Yes, yes.
After that, were they heard?
No. Once a personal hearing has already taken place, subsequent to that, if again.
After the personal hearing,
No.
a show cause was issued.
No. After the show cause, the personal hearing took place. The show cause was issued on 1st of February 2023. Subsequently, the hearing took place on 10th of February, subsequent to the show cause. 13th February, 21st February, and 27th February. Now, thereafter, my lord, if someone submits something through email to an officer, the officer has no further obligation cast upon him to grant personal hearing. And my lord,
Was
personal hearing.
that submitted after the
Yes,
response was submitted?
yes. After the personal
18th
hearing.
After 18th February
Yes.
2023?
The submission of registered taxpayer, that last submission came to us on 18th of April 2023. Now, if even subsequent to the personal hearing, if someone keeps on sending representations, maybe there are very good grounds. The authority is not obligated to keep on giving personal hearings. There has to be a finite limit to something.
My lord, I say it's a wrong hearing, my lord, but a wrong submission, my lord. As because it has fallen from your lordship on 8th of February 2023, the so-called notice was replied, my lord.
18th
18th of February.
18th April 2023.
No, actually, lordship, my lord,
18th of
I stand
April
corrected, my lord.
2023.
So
18th
after
of-
18th April 2023,
And-
was any hearing done?
It was not required under the act.
My lord, it
It
is.
was required.
It is.
No, Milord, it cannot be. Milord, the submission which they have submitted, Milord, which they have submitted on 18th April 2023, that was not a statutory response. It was at their instance they have sent a
75(4)
representation.
says so. Section 75(4).
My lord, if lordship allows
No,
me,
Milord, 75 has no application in this case. Milord,
Why?
that is wrongly canvassed.
Why?
Milord, communication and rectification of discrepancy in reduction in output tax liability and reversal of claim of reduction.
This is the general provision relating to
75
the determination of tax.
No, no, no. Milord, this is
75.
yes, 75, Milord, 70 rules. 75 rules.
Act.
Section.
Oh, section.
Here, my brother. Here.
Section 75.
Milord, I'll come to that. Milord,
Yes.
I'll just that. No difficulty, Milord. I have all the details. Milord, can be along with that. Yes, Milord, kindly Milord sees Milord the preceding provision one.
Yes.
An opportunity of hearing shall be granted where a request is received in writing from the person chargeable with tax or penalty or where any adverse decision is contemplated against that person.
Yes.
Now, Milord kindly sees in what circumstances this provision applies. Milord, where the service of notice or issuance of order is stayed by an order of a court or appellate tribunal, the period of such stay shall be excluded in computing the period specified in so and so. Where any appellate authority or appellate tribunal or court concludes that the notice issued under subsection 1 of section 74 is not substantial for the reason that the charges of fraud or willful misstatement or suppression of fact to evade tax has not been established against the person to whom the notice was issued, the proper officer shall determine the tax payable by such person, deeming as if the notice was issued. Now, this contemplates a situation where an appellate authority passes an order, where an honorable court passes an order. Third, where any order is required to be issued in pursuance of the direction of the appellate authority. Then an opportunity of hearing shall be granted. Then the proper officer shall, if sufficient cause is shown. So this is not a provision which is falling from the sky. It has to be complied with only when the preconditions of 1, 2, and 3 is complied with. And Milord, here, once the DRC1 show cause is issued, subsequent to the show cause, he has a right of a personal hearing which was granted not one date, several dates. That is admitted. Subsequently, if someone keeps on sending representation, each representation
What is
cannot.
the difficulty if after the reply a hearing is given to the
Well, it will be empty
assessee?
formality, doctrine of empty formality. What more has to be considered? He has been adequately considered. If he has any grievance, I understand. The statute provides for an appellate authority. Let him go before the appellate authority. What's stopping him from going before the
He
appellate
needs to be
authority?
heard before that, Mr. Ghosh. Give him an opportunity of hearing and then pass an order.
Milord, there cannot be any opportunity any further. Milord, opportunity also has a limit. Milord, on several dates, I have the dates with me. They are admitting to it. On 7, 8 occasions, they were personally heard. What more requires to be heard? It will be an empty formality. Milord, each and everything that they have submitted, even if Milord kindly demonstrate them, let them ask to demonstrate on the last representation what ground they have urged which have not been addressed by the adjudicating authority. Nothing.
So may I submit? Let him complete and thereafter answer. Let him complete.
So Milord, now today, once a final order has been passed by the adjudicating authority, Milord, whatever has happened earlier has merged with it. And demonstrably, Milord, there is no violation of natural justice because the statute mandates a personal hearing after the show cause. That has been squarely granted to them. And Milord, kindly sees, Milord, show cause notice in DRC 01A was issued on 1st February. Several hearings thereafter. Even then, they kept on making representations. The last representation was received on 18th of April.
The authorities are also in favor of the petitioner, actually. Have you given the references to Mr. Ghosh?
Yes, ma'am.
The authorities,
Yes,
the
ma'am.
judgments that you've referred.
Doesn't apply to the facts of this case.
One of the second judgment,
Milord,
I'll place before your lordship, whatever is fallen from Mr. Ghosh's, my lord, that has been considered by the Allahabad High Court.
The Allahabad judgment.
My lord, Allahabad High Court also, my lord, they said that you go to
Yes.
under 107 to appeal,
Yes,
my lord.
Milord,
The court has
here
held, my
the
lord.
court has returned a finding that opportunity of hearing was not granted. Let him demonstrate that no opportunity of hearing was granted to him.
My
He
lord,
admits that on several dates his authorized representative was heard.
my lord, may I submit, my lord?
Yes.
My lord. My lord, section 74 of the act, my lord, says.
Milord, para 12 once, para 12 once
Of
Puro now.
para 12
of the
judgment.
Allahabad judgment.
Yes.
It has also been admitted in the counter affidavit that except permitting the petitioner to reply to the show cause notice, opportunity of personal hearing has not been afforded to the petitioner. Thus, the legislative mandate of section 75(4) of the Act to the authorities to afford opportunity of hearing to the SSC to follow the has been completely violated. So here is a case where no opportunity was granted. And we have a case where admittedly on 5 occasions they were personally heard.
That you're admitting.
My lord, my lord,
You were heard after the show cause notice was issued. Are you admitting this fact?
My lord,
After issuance of show cause notice, you were heard on 5
no,
occasions.
no, I gave a reply. I have filed a reply.
In between,
My lord, show cause notice, I have filed a reply stating that in case you differ with it.
no. In between issuance of show cause notice and filing of your reply,
My lord,
learned counsel says you were heard on 5 occasions.
my lord, no. My lord, I'll submit. My lordship comes down to section 72.
Will you come back with the documents showing that he was heard in between?
Yes, it can be demonstrated, my lord, not a problem. I have the, my lord, written instructions with me disclosing the dates, and he is not even denying to that. Earlier he admitted, now he's saying he has not.
He is denying.
So let us
That's
come
right,
back tomorrow
that's
with the
right.
records.
Well, let me, I'll take 2 minutes. For section 74 is, my lord. The determination of tax not paid, shortly or erroneously refunded or input tax credit, my lordship, come, my lord. Section 74. Determination of tax not paid or short paid or erroneously refunded or input tax credit wrongly availed or utilized by reason of fraud or any willful misstatement or suppression of fact. Or thereafter, my lord, there are certain, the procedure has been laid to. Section 75 is the general provision. It has to be, which states, my lord, it has to be followed. Each and every 75, 1, 2, 3, 4, each and every provision has an individual identity.
No.
My lord,
General provision with regard to these. It should come
274.
one by one.
Yes, one by one. My lord, one is where the service of notice or issuance of order is stayed by any order of the court or tribunal, the period has to be excluded.
Naturally, yes.
My lord, 2 is where any appellate order, tribunal or court concludes that the notice issued under section 74(1) is not sustainable for the reason for the charges of fraud or any willful misstatement or suppression of facts or evade tax has not been established against the person to whom the notice has been issued. The proper officials shall determine the tax payable by such person, deeming as if the notice was issued under section 73(1), my lord. These are 2 different provisions. 3, my lord. Where any order is issued, required to be issued in person to direction of this appellate authority or appellate tribunal or court, such order has to be issued within 2 years. My lord, this is a period of limitation to issue it, my lord. Now, 4 is important for me, my lord, where I'm harping my case, my lord. An opportunity of hearing shall be granted where the request is received in writing from the person chargeable with tax or penalty, or where any adverse decision is contemplated against your petitioner. My lord, when the person is charged with penalties, in the final order, no, my lord. If lordship comes down to the list of dates, my lord, which has been enclosed, my lord, the index. Index to the petition.
Yes.
Index is 18.4, particularly 18.522, they have legitimate fees. Thereafter, 5 is preliminary order, 18.11.22, the preliminary order was passed. Will come,
Yes.
6 is final report, which is page number 39 to 40. Final report on 19.22, on 14, page number 47, 59. Thereafter, TRC 01A, this is a pre-consultation notice. Before issuing a proposed notice, rule 142 says that a pre-proposed notice has to be issued. But it was issued, and I have replied against this, 9/3/2023, thereafter, on GST 01, which is a so-called notice on 17/3/23, it was issued, against which I have replied on 18/4/23, Here I enter and seek a personal hearing,
Learned counsel says that you have replied in writing on 18th April. But prior to that, in between your reply and issuance of the show cause notice, you were given opportunity of hearing.
My lord, My lord, what is the?
Is it a fact?
No, my lord. I do not have any instruction as regards to this, my lord. I deny it.
So let learned counsel come back with these
My lord.
documents.
My lord, let it.
That he was heard
Yes.
after issuance of the show cause notice.
Yes. Yes.
If
My lord,
you
it is-
have been heard after issuance
Yes,
of show
yes,
cause notice,
Yes. No.
your written reply will not really matter.
No. My lord, the hearing is subsequent to the my reply, my lord. And
No.
because on that day, I have sought a personal hearing, my lord, after the reply. That is on 18th of February 2023, 18th of April 23, my lord. I have filed a reply. And in
Yes.
that reply, my lord, last paragraph was that I sought a personal hearing.
Right of personal hearing.
My lord,
Right of personal hearing is there. It is an inherent right inbuilt in all statutes. And the honorable court always carefully and vigorously protects that right. But exercise of that right has also to be seen within the scheme of the facts. Here, my lord, we are dealing with a case where, my lord, a substantial amount of tax and penalty has been admittedly, my lord, evaded. My lord, they are covered by a notification. The notification has been misused. Now, my lord, hearings after hearings, 1 year has gone by. Substantial revenue is being struck. Litigations after litigations, my lord, for what reasons?
Mr. Ghosh, why don't you spend another 2 weeks for a hearing and an order?
my
My lord, let me come back with the records tomorrow. If
Well, let it
it
come to that.
solves
Come
the
back.
if
Because 75-4 is an independent.
my lord,
Yes.
my lord, let me come back with the records. If
My lord, he has read in continuity
my lord is-
75, my lord.
if my lord is persuaded,
Independent.
my lord is persuaded to hold that yes, there is a further requirement of personal hearing, we have no problem in granting
Please
that.
show me documents that after the written
Yes,
request,
yes,
there was hearing.
Yes,
my lord.
I-
yes. Then I go out of this. After, my lord, 18/4/23.
Will you come back tomorrow?
Yes, yes, tomorrow, my lord. And my lord, my
I'll just make it not today in that case.
yes, my lord, as my lord desires.
It will not today, Rakunta. Yes, next.
Item 35, my lord.
Is it the same issue?
No, my lord. My lord, I am challenging the jurisdiction of the authority who has passed an adjudication order, raising certain taxes upon me.
My lord, I have not received instructions in this matter. My
ওটা
lord,
ওই
if you
ম্যাটারটা
can
করছি আর ওটাও
hand
fix
over
আছে।
till Monday. My lord, subject
My
to
lord,
Mr.
but I
Yes.
leave tomorrow night. It is covered, my lord. Already many matters. It has been for it has gone
Let
for
him come back with instructions. He doesn't even know whether it is covered by other matters. Come back next Tuesday.
Tuesday, my lord.
My lord, in that case, my lord, may I appear online, my lord?
Yes,
Huh?
yes, why
No,
not?
no, no.
Everyone is appearing.
Next
on
week.
it.
My lord, the principal bench has already admitted it for exchange of affidavit, my lord. I have enclosed the judgment, my lord, itself is page number, my lord, 90, my lord.
It would be a futile exercise because he is
My
not
lord,
getting instructions.
I'm
Let
just
me,
passing this.
My lord, this
I'm just
revenue
passing this
matters.
information to him.
Learned counsel for the respondents seeks to take instructions in this matter. Paragraph, let the matter appear under the same heading on 8th August,
Tuesday, my lord.
Tuesday, 8th August.
Grateful, Lordship.
Well, item 35 is the next matter.
Another 3 PM matter.
Item 35. Well, I am for the petitioner in this matter. শুনতে পাচ্ছেন? Well, I am for the petitioner. I am audible to your lordship. I
Yes,
understand.
yes, now you are. Yes.
Grateful to your lordship. Kindly come to straightway page 22. It is a case, my lord, for transfer, prayer for transfer made by a lady teacher. Page 22, page 22.
Yes,
22.
yes.
The order of the Honorable Justice Kiranmay Bhattacharya.
It's the same petitioner.
Same petition. Previous round of writ petition, where the application for transfer was directed to be considered by the District Inspector of Schools. There was certain ingredients for transfer which were duly satisfied by the petitioner, and accordingly, my lord, it was accepted that
Yes.
it was accepted that your case should be considered by the District Inspector of Schools. Kindly come to my lord, page 23. Accordingly, at the bottom,
Yes, yes.
accordingly, WPA is disposed of by directing DI of school to consider the representation of petitioner dated so and so. DI considered it.
Yes,
Considered it, page 25.
yes.
Page 25 is the order of DI. He wants that I should be immediately given transfer. Because I am traveling by a scooty 35-kilometer hilly area, my lord, and mudded road, for which I had to terminate my first baby. I could not conceive. Thereafter, my lord, I was having the 10 years I have suffered this plight. And my lord, after this matter was ultimately considered DI. DI recommended for transfer. Kindly come to page 27. Kindly go. Has the lordship got page 27?
Yes.
Lordship has read the order of DI. Ultimately, the DI said that he should be on all round satisfaction is there. My application was the movement of my application is chronologically stated in page 27. Lordship kindly come at the top.
I do not understand one thing. The district inspector of schools say that the application be forwarded to the district inspector of schools. How is that possible?
For making recommendation, my lord, Lordship kindly come hence.
But he is the district inspector of schools himself.
Page 26, kindly come. Hence, in the light of the aforesaid provision of the prevailing government order, observation made by High Court, having heard the regard to the facts and circumstances, materials on record, applicable, it is held that the role of head of the institution does not contemplate a correct proposition of law. Therefore, the transfer application on special ground of Madhumita shall be forwarded to the end of the district inspector of school as expeditiously as possible.
So he is writing to himself.
No, he is wanting to say that you, the school, you forwarded it to me. Unless the school forward the application, DI cannot take any steps. Directed the school, if don't withhold it, you are bound to forward it to me. Accordingly, the DI school was directed to forward it to the DI of schools as expeditiously as possible without making any excuse by observing necessary formality.
Who was directed?
School authority was directed.
Where is that stated?
That is there. Accordingly, this was the decision taken, holding that the decision of the school was wrong. Kindly come to it is held, role of the head of the institution, that is the school authority, does not contemplate a correct proposition of law.
Yes, so
kindly mark this sentence.
This has not been forwarded.
This has not been forwarded by the DI. And thereafter, after this order, the DI, the school authority forwarded it to the DI. DI, upon consideration of everything, forwarded to the Commissioner of School Education for transfer. That will appear at page 27. 7th of left-hand side top manner, the date is there. Just before that date, head of the institution is forwarding to the DI of schools on 1st October 2022. Has you already got it? Left-hand side, Utsosri. Left-hand side at the page 27 at the top. Utsosri is a transfer policy.
Yes.
Utsosri is a transfer policy. The application for transfer is to be made to the school. School is to consider it. School has ultimately referred it to the head of the institution, has referred it to the DI of schools. Lordship will get the second one forwarded 1st of October 22 to by the head of the institution to the DI of schools.
Yes.
Has the Lordship got it?
Yes, yes.
Now the DI of schools has forwarded to the West Bengal. Next, just the top of it. 7th of November 2022, DI of schools forwarded the application for transfer
To the council.
Commission.
To the School Service Commission. Yes. He is again muted. Mr. Bhattacharya. This is happening from yesterday. Yes, please continue. Then what? What is the prayer?
with the recommendation.
The commission, till now, commission did not take any decision regarding the transfer. School service commission.
So the SSC has to take a decision.
So Millard, I am for the School Service Commission. Millard, since the outsourcing portal is now suspended by way of a government order, Millard is aware of this. Millard, no transfer orders are being processed at this moment. So Millard, they have to wait for some time. And Millard, the entire online process was Millard rolled out Millard to remove all the
But
disputes.
the
And
candidates will suffer due to the
Millard, it's happening
non-functioning of.
throughout the state. Millard, all transfer applications are now being kept on hold.
Because that, the application was forwarded. Yeah. What is it? That-
State.
Only in March 2023.
Yes.
That was not a case of November 2022. Therefore, prior to that, since it is recommended, you are bound to recommend the case.
The online.
It has happened prior to the said.
Suspended.
Yes. It's
The online portal is suspended for the time being. So Learned Council says that all the candidates have to wait for some time.
Well, that has been suspended subsequently. Not
So if the
suspended
portal
at the
is-
time when it was recommended.
So if the portal
If
is
the
suspended,
recommend-
how can they function? Mr. Bhattacharya, if the portal is suspended, how can they function?
All persons who applied prior to that, they got the benefit. Suspension came in March 2023. And before that, there was no suspension. Now from November, they kept tight about the issue. Prior to that, I filed a writ petition. First writ petition, Lordship will kindly look at order. They
Since
did not
I
say
have to
that.
pass an order as on this date. Can it be passed? What has happened earlier has happened. I understand that the petitioner has suffered. But
It's
since the portal is
It's
suspended,
suspended since September 2022. And subsequently, the suspension has now been extended for some more time.
so all the candidates. will suffer.
There was no suspension in July 22,
Correct, Millard, but this is the.
not in November 22.
That the portal is not operated by the School Service Commission. It is operated by the School Education Department. That is the state.
So if there's a suspension of the online thing, it can't be done offline.
Millard,
Physically.
Millard, in certain exceptional cases.
They cannot suspend it, my lord. I tell you, Lordship,
Court is passing orders.
there cannot be any suspension of the rule. There is a transfer rule is there.
Order passed.
Millard, but those.
According to the statutory rule, I am entitled to.
Offline consideration has been ordered, Millard, are those cases which demonstrates, Millard, exceptional circumstances like a severe disease or Millard, something of that sort, Millard, which is very, Millard, of very high.
This is
degree
also
of
a special ground transfer, my lord.
This
demonstrated.
this.
It is also a special ground transfer. I am suffering from severe disease because of the long scooty
Order
drive for
passed by this
7 kilometers per
court
day.
from 14th July 2022.
Yes, Millard.
So this is sufficient ground. We are in 2023, more than a year.
If Millard desires the School Service Commission, Millard, to consider his application, that can be done.
Yes.
There is no difficulty.
Let them consider and pass an order.
That can be
Let the
done.
Commissioner of School Education
Only if the school.
pass appropriate
is
order.
closed down, the candidates cannot suffer.
Millard, the difficulty what crops up is, Millard, for a particular school, Millard, there are several transfer applications from the said school. If we cannot access the portal, we don't know who are the competing candidates, Millard, where are the
Take up
ranks.
this individual case and do it.
Their transfers are being done, my lord. Lot of transfers have been given.
Petitioner
If they so want, I can show it to your lordship.
is an assistant, is appointed as an assistant teacher at Salmara High School, Dinhata, Coach Bihar. And made an application for general transfer on 2nd August 2021. Yes. Not serve the state. Yes.
Kindly look at the DI's order. Page 25.
Mr. Bhattacharya, you have not served the state at
State
Jalpaiguri.
is served. I have given the video service.
Where is the affidavit of service? Where is the
Here,
affidavit? Where is the affidavit of service? is the affidavit of service?
Milord, Mr. Kundu says he will make over a copy, Milord, since Milord is disposing of the matter probably, Milord.
So tomorrow for orders. For orders tomorrow. Should be everything for orders.
Affidavit of service is not there.
No.
কি খেলা লাগাস কাকে কাকে লাগিয়েছিস
Get it.
দেবজিৎ আছে মনে
Mr. Bhattacharya, for orders tomorrow.
as your lordship
Let copy be served.
পুলিশ তোরা আমি বুঝি তোর উপর দায়িত্ব দিচ্ছি
Item number 76 is not known. Time cannot be fixed, sir. I'm sorry. Come back tomorrow. Let us see. I must have to rise in 5 minutes. There's a meeting with the Honorable Chief Justice. So another 5 minutes I have to rise. Yes, 43 is a short matter. Yes? Yes, this will be the last matter.
This is my appearance for this one.
Who is appearing for the petitioner?
Well, I appear on behalf of the petitioner.
Have you
I-
served?
Yes. Well, I challenge the order, passed by
Who
the,
is appearing for the respondents?
I don't know, well, this is against the highway authority. Well, I challenge the order passed by the respondent.
Jalpaiguri, Commissioner, Jalpaiguri Division.
Yes, yes. That is the authority against order passed by the, my lord, respond number 2.
National Highways Authority.
Yes.
National Highways Authority and the state who are appearing. Anyone appearing for the National Highways Authority and the state?
Last page, the national, my lord, respond number 2.
Yes.
If Singh is appearing usually, but today, Mr. Ghosh substituted for her.
Where is Mr. Ghosh? So not today? Will you come back tomorrow?
This thing will be there.
Will she come tomorrow? So not today.
Number
44.
Before my lord rises, one request, Lord, item 83 of today's list. Your lordship, Lord, this was marked for today in the list. Lord, Lord, may it be taken up tomorrow at 2 p.m. Lord, if
Be
it,
marked for today.
it was till yesterday, it was marked for today. Second August, not till yesterday, it was marked for today. Second August, it was marked for today. Mr. Das, Lord, mentioned the matter, Lord, and Lord.
Did I mark it for today?
Yes, yes. So
We are
Lord,
taking it.
may,
Oh, it was.
Lord, may it be taken up tomorrow. Lord, may it be taken up tomorrow at any time, Lord.
Will appear tomorrow,
My
but I
lord,
should reach. Let us see if
Lord,
I can.
may it be taken up tomorrow, any fixed time if it's
It is not
possible.
fixed
Lord.
time here, you are aware. I have to take up all matters serially.
Lord,
Cannot fix a time here.
we are suffering, Lord. If it comes to, it will take only
Any
5
one
minutes.
case
time.
where they are not suffering and they have still come
I
to court.
understand, Lord. I understand that, Lord. If, but
My
if
lord, if-
possible, Lord.
Please come back, let us see.
My lord, we could have lost it, right, my lord, item number 43. And I have other matters, my lord, 45 to 40. Would it be a lordship's pleasure to, my lord, upgrade this matter so that matter can be taken up by, my lord, tomorrow?
It will appear in the list, sir. You have heard I am not updating any matter. So please come back. I am here for a very short time. I have to call the list.
item number 49. Well, it's a very
Tomorrow.
short matter.
Tomorrow, sir. I'm sorry.
উঠে গেল উঠে গেল
বাবা দেখুন তো আরেকবার বসে বসান
না, আপনি যেটা বললেন তাই বলছি।
Accordingly list.